share the link first in my Telegram channel. शो नहीं हो रहा क्या? Yes. Okay. So hi everyone. Is there anyone? Am I audible? Please can anyone tell me that am I audible or not? Otherwise I'm going to continue the class, guys. Okay. So what are we going to discuss in this class? Let me discuss quickly. Number first, it's going to be the remaining part of director, which include the dividend wala part and all, ठीक है, and accounts and audit. ये and with that we are going for the डिजिटल क्राइम वाला जो पार्ट है अपना, ठीक है, साइबर क्राइम वाला पार्ट है वो, एंड दिस विल बी इन वेरी क्विक. We are not going in depth, just reading, or I'm going to tell you the important one. That's it, okay? And with this, we are going for the past previous year question paper for like 4 attempt, and one would be like for the syllabus 2016, and another would be of 2022. And so in total, there is going to be 5 question papers, okay, of corporate and economic law for CMA final students. Okay, so yes, let's not waste our time and let's do it. Okay, so I'm having the scanner of December 24 attempt, so I'll be quick, guys. I'm not going in depth. Let me say it again. Okay, so I'm going for the dividend chapter first and page number 13.55 as per the December 24 attempt scanner. Okay, so let me read the question, and with that question I'll explain you what is the matter inside the question. Okay, so Treza Limited declared dividend for the financial year 2013 and 2014 on the 4th July 2014, but did not pay the same to the shareholder within the prescribed time. So once the dividend is declared, it should be paid. If it is not paid, there would be some consequences which the director and the company have to face. So let's see what is this. Explain with the reference to the provision of the Companies Act 2013 and what are the penal provision against such a violation. And second point, under what circumstances no offence shall be deemed to have committed. So number 4, as per section 127, dividend has not been paid or warrant in respect thereof which is not paid. Once it's declared, should be paid. So within how much days? Within 30 days of its declaration. Okay, and in case there is going to be a default, and that is of the 100,000 rupees, which should not be less than 1,000 rupees, and 2 years of the imprisonment. And there would be some cases again where the second case is saying what are the circumstances no offences shall be deemed to have been committed. So the other cases where no offences under section 127 of the Companies Act shall be deemed to have been committed, that is if it is where the dividend could not be paid by the reason of operation of law, where the director have the shareholder have given the direction to the company but it was not circulated. Okay, third, disputed regarding the rights of to receive the dividend. There was some dispute, and just because of that the dividend could not declared. 4, dividend has been lawfully adjusted by the company against any sum due it from the shareholder. And the 5th, where any other reason the failure to pay the dividend or post the warrant within the said period was not due default of part of the company. So there are the cases, there are 5 cases in which there is the company or the director would not go for the panel and all. Okay. Okay, hi everyone, am I audible? Is there anyone? Because in my device they is showing 2 person are live with me, so just tell me am I audible or not. Okay, So okay, there is one more question. Let me go for the other part, okay, where the section question is of December 2015, okay, which says PWL Limited is facing loss in business during the current financial year 2015-16 in the immediate preceding financial year. So here the company is incurring the loss, and now the question would be like whether they can go for declaration of dividend and what would be amount of percentage of declaration of the dividend. Okay, so here in the immediate preceding 3 financial year, the company had declared the dividend, which is 8%, 10% and 12% respectively. Number first point, okay. Number first was that the company incurred the loss. Second is that they have declared the dividend for the 3 years, okay. To maintain the goodwill of the company, the BOD had declared to 12% of interim dividend for the current financial year. Examine the applicable provision of the Companies Act 2013 and state whether the BOD can do so. So yes, number first, from where the interim dividend can be declared during the financial year, we have to understand out of the surplus in the P&L account or out of the profit of the financial year. So out of the surplus or out of the profit of the financial year, okay, in which such interim dividends sought to be declared. And what would be the highest amount where the percentage where the company can declare, as they was going through they was incurring the losses, right? So let's go for the last part of this question. In the given case, the company is facing loss during the financial year, current financial year 2015-16, the immediate preceding financial year, the company declared dividend at the rate of 8%, 10%, 12%. So here the company cannot go for the average of these 3 financial year. We will take the average of these 3, and that could not be more than that. Okay, if they are going for that, then that would be violation. Okay, so here 8, 10, 12, as per the above mentioned provisions, such interim dividend shall not be declared the higher than the average dividend declared by the company during the immediate preceding 3 financial year. Okay, so which is 8, 10, 12. Okay, so that is going to be 13 divided by 3 and 10%. Therefore, the decision of the BOD to declare 12% of interim dividend for the current financial year, it's not tenable. Okay, it's not going to be possible. The company cannot declare it, because if they are going to declare 8% or like 9%, then they can go for it. In the given question, it was 12%. Okay, so this is also important, guys. Let's go for the other part, which is, let me read, which is question number from December 2019, and the page number is 13.61. Hi anyone, if there is anyone live, so can you tell me am I audible or not first? बस एक बार बता दो मुझे, क्योंकि मैं तो बोलती जा रही हूँ, मुझे तो पता नहीं कि आवाज़ आ भी रही है या नहीं. ठीक है, so yes, the question number 2019, page number 13.61, as per my scanner, December 24 वाला. ठीक है, so the BOD of the XYZ company limited as its meeting declared a dividend on its paid up equity share capital, which later on approved by the company's annual general meeting in a resolution to divert the total dividend to be paid to the shareholder for purchase of investment for the company. As a result, the dividend was paid shareholder after 45 days. Okay. So first of all, within how much days the dividend should be paid once it's declared? Within 30 days. And if within that 30 days the dividend is not paid to the shareholder, 30 days, here in the question they have given 45 days. So what should be the procedure to be done? Because within next 7 days, once this 30 days is ho gaya, hai na, from the another 7 days, it should be deposit to unpaid dividend account within 7 days. MCQ आया है, ठीक है. So this is going to the provision here. The company have not declared within the 30 days, right? So yes, it's going to be deposit in the unpaid dividend account within 7 days. Okay, so this was all about this point. But what is going to be penalty here for the company? It's going to be the fine of 1 lakh with 500 if the penalty is going to be continue. Okay, and maximum it's going to be 10 lakh. Okay, so what about the officer? It's going to be 25,000. If it's continuing, then 100 rupees for per day, and maximum it's going to be 2 lakh. So this about the section 1 to 4, guys. So these were the main section related to dividend, and let's go for the other part guys, which is related to audit वाला, audit, account and audit. ठीक है, पेज नंबर 13.72. ओके, आई एम गोइंग टू टेल यू द क्वेश्चन फर्स्ट, कौन से के हिसाब से अपन करते हैं. ओके, so there is a question from December 2013. The liability, page number 13.3 is 13.73. December 2013 का क्वेश्चन है. आई एम सेइंग अगेन गाइस, कैन एनीवन टेल मी एम आई ऑडिबल और नॉट? बस एक बार बोल दो, क्योंकि मैं तो बोलती जा रही हूँ, मुझे पता नहीं आप लोगों को सुनाई दे रहा है या नहीं. प्लीज़ एनीवन, इफ़ यू आर ऑनलाइन, प्लीज़ कमेंट एम आई ऑडिबल और नॉट. ओके, लेट्स गो. December 2013, द लाइबिलिटी ऑफ ऑडिट फीस. ये क्वेश्चन आया भी है. ठीक है, स्कैनर में जितने भी क्वेश्चंस आप देखोगे ना, वो ज़्यादातर आए हैं. उसमें आपको दिख सकता है कि दे हैव रिटन जून 2015, दिसंबर 2013, है ना. ऐसे मत सोचना कि दिसंबर 2013 का है और आएगा नहीं. मैं आपको बताऊँ, इन दैट ड्यूरिंग कोरोना टाइम, ओके, जब ऑनलाइन हुआ था, एंड एट दैट टाइम सिलेबस वॉज ऑफ 2016. आपको पता है, इन CFR क्वेश्चन फ्रॉम वो शेयर बेस्ड पेमेंट वाले में से 2012 का क्वेश्चन आया था. समझ रहे हो, है ना. तो ऐसा नहीं सोचना कि क्वेश्चन नहीं आ सकता. क्वेश्चन कहीं से भी आ सकता है, कभी कभी बहुत घुमा कर आ जाता है. ओके, सो लेट्स गो फॉर दिस पार्ट. द लाइबिलिटी ऑफ द ऑडिट फीस हैज़ बीन आउटस्टैंडिंग सिंस लास्ट 2 years. Audit fees is not paid. The work which is done by auditor, the company have not paid them, the auditor, the fees. Okay, this year after completion of audit, the auditor informed to the secretary of the company over a phone to bring the check of all 3 years. So what they are saying, this year after completion of audit होने के बाद, the auditor informed to the secretary of a company over a phone to bring the check of all 3 years and take delivery of the audit report. Okay, so we have to discuss briefly about the statement in the context of the right of auditor to receive remuneration. So as per section 142, there is a fixation of remuneration of auditor. ठीक है, there is right of auditor to receive the remuneration, compensation, remuneration, ठीक है, just after completion of his work. So his work was actually completed earlier, है ना, and once he submitted his audit report, he will get the amount, which means the remuneration. Okay, or this was the first point. Second point, he may also get the remuneration in form of percentage of his completion of work. तो ये दोनों में से कोई भी हो सकता है. ओके ओके, सेकेंड वॉज ऑफ प्रोग्रेसिव बेसिस जिसको कहते हैं. तो फर्स्ट नंबर, एज पर सेक्शन 142, दिस इज right to receive remuneration after completion of his work, and second is progressive nature. ठीक है, okay, so let's go for the other important question guys. important सब है, ऐसा नहीं है कि सिर्फ जो मैं बता रही हूँ वही important है. you have to go through each and everything guys, है ना. इट में जो भी आप छोड़ के जाओगे ना, वो आएगा एग्जाम में, ये सोच लो. तो आपको कुछ भी नहीं छोड़ना. ओके, लेट्स गो फॉर जून 2019 अटेम्प्ट. Page number 13.79. Explain the particular required to contain in director responsibility statement as per provision of the Companies Act 2019. So here they are asking about the context of the director responsibility statement, what it should be or what is going to be. आपके दिमाग में तो होगा थोड़ा बहुत, ठीक है, which is related to accounting statement should be followed, है ना, that should be proper explained with that, it should apply consistency, ठीक है, which gives the true and fair view, and director have taken proper sufficient take care of and all asset and all. ठीक है, हाँ जी. so these are basic main point which we know going concern होना चाहिए, है ना. so that is what they are asking. we have to write each and everything which is related to this. ठीक है, so read it again guys. ठीक है, एक बार read कर लीजिएगा अपने हिसाब से. let's go for the other point. yes, important one, internal auditor से related है. ठीक है, क्वेश्चन इज़ ऑफ December 2017. गाइज, एम आई ऑडिबल? मुझे एक बार बता दो, राइट, क्योंकि मुझे पता ही नहीं. एक बार मुझे ही देखने दो. कोई कुछ बोल ही नहीं रहा, पता नहीं क्यों नहीं बोल रहा कोई. जस्ट अ सेकेंड. रीड क्वेश्चन 2017 दिसंबर वाला अटेम्प्ट तब तक, विच इज़ रिलेटेड टू इंटरनल ऑडिटर, एंड होप यू नो वट आर दी एप्लीकेबिलिटी ऑफ द प्रोविजन फॉर द इंटरनल ऑडिटर. तब तक मैं अपने आप को देखती हूँ कि मैं सुनाई दे रही हूँ या नहीं, बिकॉज आप में से कोई तो बोल ही नहीं रहा मुझे. हाँ, थैंक गॉड. ओके, ऑल गुड. पता नहीं क्या हो गया, कोई बता ही नहीं रहा भाई, पढ़ना ही नहीं लगता है किसी को. ओके, लेट्स गो फॉर द December 2017 question, 13.81 page. Interior Private Limited is manufacturing company having a turnover of 210 crore but having maximum outstanding loan from public financial institution of rupees 90 crore. ठीक है, so first was turnover 210 crore. Okay जी, okay, and they are private limited company. Okay जी, okay, and they have outstanding loan from public financial institution which is of 90 crore only during the preceding financial year. You are required to state whether the company is liable for the internal audit as per the provision of the Companies Act 2013 or not. So first of all, there is some criteria for that. For the listed company, every listed company have to appoint the internal auditor. But for the public company and for the private company, there is going to be a limit, and let's read the limit. For the unlisted public company, where the paid up share capital for the preceding financial year is going to be 50 crore or more. The turnover is going to be 200 crore or more for preceding financial year. ठीक है, outstanding loan and borrowing from the bank, the public financial institution, should exceed 100 crore or more, and the outstanding deposit of 25 crore or more. ठीक है, okay. So let me say paid up share capital 50. हाँ जी, टर्नओवर कितना था अपना 200 करोड़ और मोर. ओके जी, एंड आउटस्टैंडिंग लोन वगैरह क्या था अपना, दैट वाज ऑफ 100 करोड़, राइट, एंड डिपॉजिट कितना था 25. सो इन क्वेश्चन द टर्नओवर इज this is related to the unlisted public company, by the way. Okay, so there is one more, because question is asking about the private company, so there is one more criteria for the private company, and that is going to be what, the turnover. Okay, and the outstanding loan same है, जो भी टर्नओवर ऊपर था ना 200 करोड़, बिल्कुल वही, ठीक है, एंड द आउटस्टैंडिंग लोन 100 करोड़ मोर. ओके ओके, so here the question, in the question the turnover is going to be 210 crore, okay, and the outstanding loan from the public financial institution is 90 crore. Okay, so you have to tell me whether the company have to appoint the internal auditor. This is going to be private company, so yes, because the turnover is more than 200, which is 210. Okay, so here they have to appoint the internal auditor. बस ठीक है. The another question just उससे नीचे का है, June 2018. Let me read. X Limited appointed CA Innocent as a statutory auditor for the company for the current financial year. Okay. Further, the company offered him the service of the company offered him the services of actuarial, investment advisory, and the investment banking, which was also approved by BOD. So first of all, we have to know the internal auditor is going to be appointed for internal audit. The other services, there are some specified services he cannot render, first of all, ठीक है, whether it is approved by BOD or not. Internal auditor किस लिए अपॉइंट हुआ था भैया, इंटरनल ऑडिटिंग के लिए हुआ था, तो he is only going to do that thing. Let's read it. An audit appointed under the act shall provide the company only such other services are approved by BOD or the audit committee. Here they are saying, okay, as the case may be, but which may not include any of the following services. Okay, whether such services are rendering directly or indirectly to the company or its holding company or a subsidiary company, namely accounting and bookkeeping services, the internal audit, the design and implementation of the financial information system, the actuarial services, the investment advisory services, the investment banking services, and with that the rendering of outsourced services, financial services and management services, and any other which is prescribed. Okay, let's read further. 141 subsection 3 clause 1 of the Companies Act also disqualify a person for appointment as an auditor of the company who is engaged as date of the appointment in consulting and specialized service as provided in as per section 144. So in the given case, CA Innocent was appointed as an auditor of X Limited. He was offered additional services of the actuarial, investment advisory and the investment banking, which was approved by the BOD. The auditor is advised not to accept the service, as these services specifically notified in the services not to rendered, take by him as auditor as per section 144. So whether in this case it was approved by BOD, he will not go for these services. Okay ji, haan ji. So let's go for the other important, which is again continuation wala part here guys. ठीक है, एक बार रीड लगा लेते हैं. December 2018. Mr. Faithful is an auditor of the Daga Limited. ठीक है, while auditing the accounts of the Daga Limited of 2016-17, he find manipulation of the fund around rupees 2 crore committed by the officer of the company. Okay. ठीक है, इतनी बात समझ में आ गई. अगेंस्ट द दागा लिमिटेड. सो एग्जामिन इन द लाइट ऑफ द कंपनीज एक्ट 2013 द वे फ्रॉड आर रिक्वायर्ड to be reported by Mr. Faithful and duty of the Daga Limited in relation to reporting of such fraud. So here, once the auditor get to know about the fraud, he have to inform the BOD and audit committee, and then once he is going to inform the board of director and audit committee, he is going to wait till 45 days. ठीक है, but within how much days he have to wait, and there is one more specified point which is saying कि the fraud should be of some amount. ठीक है, if it is up to that amount or more than that amount, then only he can take action, otherwise ठीक है, the company is saying that. ठीक है, okay. So which in here they are saying which involve its individually as amount of rupees 1 crore or above is being or has been committed against the company by its has a reason to believe that the offense of fraud which involve or is expected to involve individually an amount of rupees 1 crore or more, yes, is being or has been committed against the company by its officer or the employee. The auditor shall report the matter to central government. But उससे पहले he have to give the information to the audit committee, ठीक है, and BOD within 2 days. Within 2 days when he get to know about the fraud. ठीक है, जैसे उसको पता चले फ्रॉड के बारे में, he have to inform the BOD and audit committee. Okay जी, okay. And he will wait till 45 days. Within 45 days, the BOD and the audit committee is going to give the reply and the observation, okay. And he have to forward the observation and the reply to the central government within next 15 days. What if the board of directors and the audit committee didn't give any reply or observation within that 45 days? Then again, the auditor have to give the reply. With that, they have not given the specified authorities have not given the observation or reply on the report which was given by the auditor, okay. That is to be forwarded to the central government within 15 days, okay. And with that, one more thing which is another point number, let's go for it. Fourth, report shall be sent to the secretary, okay, Ministry of Corporate Affairs in the sealed cover by the registered post with acknowledgement due or speed post followed by the email in confirmation of the same. Fifth point is about the report shall be on the letterhead of the auditor containing postal address, email address and the contact telephone number or mobile number, and be signed by the auditor with his seal and shall indicate his the membership number. And last, the report shall be in form of statement as specified in format ADT 4. इतनी बात समझ में आ गई. ये थोड़ी चीज़ें थोड़ी रटने की है, ठीक है, ऊपर वाली मैंने आपको बता दी, ओके. सो दिस वाज ऑल अबाउट द पॉइंट, एंड विद दैट इट शुड the particular should in the information about the parties should be mentioned there, okay. The amount should be mentioned there, the remedial and the penalty involved, सब कुछ उसमें information होना चाहिए, ठीक है जी हाँ. And just go to June 2023 question guys, you have to do this. वैसे तो आपको सब कुछ करना है, बट मैंने आपको सिर्फ थोड़ा थोड़ा हाईलाइट बताया, ओके, बिकॉज अब अपन इतने डिटेलिंग में जा नहीं सकते इस टाइम पे, ओके. Okay, let's go for the first part guys, okay, company's formation and conversation का. उसमें से मैं थोड़ा थोड़ा बता देती हूँ कुछ, okay. इसमें से आप ये वाला क्वेश्चन देख लीजिएगा which is related to December 2013 partners and designation partners in LLP, okay. And one I'll say कि where the office is changed from one place to another place. What if the registered office is changed in same state, इसके बारे में देख लेना. And what if it's changed from one place to another place, ठीक है, from which people the prior information is to be given and approval is to be taken, okay. ये एक बार देख लीजिएगा आप, that is important. MCQ के फॉर्म में भी आया, क्वेश्चन भी पूछा गया. And let's go for this part guys, June 2018, okay. इसके बारे में एक बार थोड़ा सा पढ़ लेते हैं अपन. 13.30 पेज नंबर. The secretary of a company issued a share certificate to Prem under the company seal with his own signature and the signature of the director forged by him. ये कौन सा केस है, ये अपने को जानना है. ओके. प्रेम borrowed money from the Amar on the strength of this certificate and Amar wanted to realize the security and requested the company to register him as a holder of the shares. Okay. Explain whether the Amar will succeed in getting the share registered in his name. Explain the help of the doctrine of indoor management in brief. So first of all, we have to understand what is the meaning of doctrine of construction. ठीक है, with the doctrine of construction protect the company against outsider, whereas doctrine of indoor management protect outsider against the action of a company. ठीक है, so there are two terms which is saying doctrine of management and which is also known as Turquoise rule. ठीक है, and the second is going to be doctrine of construction notice. So I am saying it again, I am repeating it again. The doctrine of constructive notice protect the company against outsider, whereas the doctrine of indoor management protect outsider against the action of the company. ठीक है, okay. So let's read the provision which is written. I am going for third point. The doctrine also in the possible safeguard against the possibility of the abusing the doctrine of construction notice. The person entering into transaction with the company only needed to satisfy that his proposed transaction is not inconsistent with the articles and memorandum of the company. Okay. So with that, he is not bound to see the internal irregulation of the company. Let's go for point 1, 2, 3, 4. Fourth point of this page 13.31. However, the doctrine has several exceptions, one of them being forgery. Rule does not apply to transaction involve forgery or illegal transaction and the transaction is going to be void of inertia. स्टार्टिंग से void मान लिया जाएगा इसको. ठीक है, हाँ जी. So in this case there was involved of forgery. So yes, this was the case and it's not going to be valid. यही बात इसमें की गई है. ओके, सो एक बार रीडिंग लगा लीजिएगा आप लोग इसके and let me see if there is something else, otherwise we will go to the other part. ओके, सो इसमें इतना कुछ नहीं, एक बार प्रोड्यूसर कंपनी के बारे में देख लेना जो मैंने आपको बताया था. द कंपनी इज़ गोइंग टू चेंज फ्रॉम वन प्लेस टू अनदर और व्हाट इज़ टू बी डन. ठीक है, प्रोसीजर इज़ टू बी डन. लेट्स गो फॉर द साइबर क्राइम गाइस. आई विल बी क्विक अगेन, देन विल गो फॉर द क्वेश्चंस, प्रीवियस ईयर क्वेश्चन पेपर. Okay, we are going with the module first of all of our CMA module. Okay, and let's go for the page number is 381. So what is the objective of IT Act? We have to understand that first. Okay, that is the legal recognition of the electronic transaction. Okay, which facilitate the electronic filing. With that, consequential amendment to any other activities act. And what are the offenses which is going to be included here? This tampering with the computer sourced documents which involve the hacking, destruction, deletion, alteration of any of the data. ठीक है, which is in any computer with intention to damage that, and which include misrepresentation or the breach of confidentiality. Okay, I'm just reading the main part. Okay, I'm not going in depth guys. Next page में है 382 में the settlement of dispute. So whether there is going to be any authority where the person, the aggrieved person can go and appeal for the crime which is related to cyber crime. ठीक है, हाँ जी, ये अपने को थोड़ा बहुत पता भी है. Let's go for it. The central government has appointed the educating authority having its a legal knowledge of cyber regulating appellate tribunal, and within how much days? Within 45 days. And then the decision of appellate tribunal can be appealed to high court. तो यहाँ पे तो फर्स्ट ऑफ ऑल साइबर रेगुलेटरी appellate ट्रिब्यूनल के पास within 45 days, and अगर if the person, aggrieved person is not satisfied by the decision which was given by the appellate tribunal, then again they can go for to the high court within 60 days. Okay, within 60 days of the order passed by that appellate tribunal. Let's go for page number 384. Okay, so what is this business intelligence? We have to understand that business intelligence is a technology. ठीक है, which is a driven process of two thing which is first is going to be analyzing of data को analyze करने का, second delivering that actionable information to three people, to the executive, to the manager and to the worker, which is going to help to make a decision, business decision, informed business decision, and with that to make a strategic planning for future. So let me say it again, कि it is a technology which is a driven process of analyzing data with delivery actionable information, which is going to help the executive, the manager and the workers, which is the employees and all, ठीक है, to in what way that is going to help them to make the business decision, to take the business decision, or for the strategic with strategic planning. Okay, so what is their goal? To make the better business decision, increase the revenue with that, improve the operational efficiency, gain the competitive advantage on the business rival. These are the main goal, ठीक है. And what are the steps involved? Data preparation, analytical query, distribution of KPI, use of information. Okay, so there you can see some of the benefit of business intelligence, which is speed up, improve in decision making, increase in productivity, increase in efficiency of the work. Before the threat is going to occur, the company can get the information, ठीक है. So these are the main thing. Okay, what are the types of business information tool? ad hoc, ठीक है, ऑनलाइन, ठीक है, ओलैब जिसको अपन बोलते हैं, मोबाइल BI, रियल टाइम BI, ऑपरेशनल इंटेलिजेंट BI, एम्बेडेड BI, कोलैबोरेटिव BI, लोकेशन BI, ठीक है. एक बार इसको बस नाम के साथ डिटेलिंग हल्के से पढ़ लेना, फिर आपको याद हो जाएगा. ओके, लेट्स गो फॉर द अदर पॉइंट विच इज ऑफ द 383. व्हाट इज साइबर क्राइम? साइबर क्राइम नाम से पता चल रहा है अपने को. इट इज़ यूज टू डिफाइन द क्रिमिनल एक्टिविटी इन विच कंप्यूटर एंड द कंप्यूटर नेटवर्क आर गोइंग टू बी टोल्ड. डेफिनेटली साइबर की बात करें, देख सुना नहीं है कि आजकल बहुत सारा फ्रॉड हो रहा है ना. वो कॉल आते हैं, मेरे को भी आया था एक कॉल, ठीक है. किससे आया था? द पर्सन वॉज कॉलिंग मी एंड ही सेड कि बेटा आपके पापा का अकाउंट में मुझे पैसे, पापा को पैसे देने हैं. और कितने पैसे देना? 12,000 रुपये देने हैं, ठीक है. और मैंने कहा अच्छा जी अंकल जी, ठीक है जी. देन ही टोल्ड मी कि आपकी इसी नंबर पे पेटीएम कर दूँ. मैंने कहा हाँ, मैं आई वाज जस्ट देन ही आस्क्ड मी अगेन कि बेटा इसी नंबर पे मैं पेटीएम कर दूँ. मैंने कहा इसी नंबर पे मैं पुलिस को बता दूँ कि तुमने मुझे कॉल किया है. एंड ही जस्ट रैंग द फ़ोन, ठीक है. उसने काट दिया उस बंदे ने फ़ोन. तो इस फ्रॉड के चक्कर में मत पड़ जाना, ठीक है. फालतू लड़कियों के चक्करों में मत पड़ जाना. ये भी चीज़ मैंने सुना है कि सम फेक गर्ल्स आर कॉलिंग बॉयज़, और लड़के इस चक्कर में पड़ जाते हैं, फिर पैसे वो लोग लेते हैं. बहुत सारी चीज़ें इसमें, ठीक है. So this is cyber crime, which is used to define the criminal activity and in which computer and a computer network are basically the tool and target or a place of criminal activity. Let's say the credit card fraud, है ना, the child pornography और the illegal downloading. अपन कहीं बार कोई वेबसाइट खोलते हैं तो कोई और चीज़ डाउनलोड हो जाती है ना. So these are the main tool of the cyber crime. Okay. So let's go for some of the type of the cyber crime, which is number first, the cyber crime against a person, number second against a property, number third it's going to be against the government. So for against a person, what it could be, अपन को थोड़े बहुत तो पता है ना, जैसे कि स्टॉकिंग. अपन सब स्टॉकिंग करते हैं ना, है ना, बस वही, ठीक है. सेकेंड ऑफ ऑब्ससेनिटी विच इंक्लूड द प्रोनोग्राफी. Okay, third of defamation, where in this case hacking mail account and sending somebody else. Okay, where this, एक बार मैं थोड़ा सा पढ़ लेती हूँ defamation के बारे में. It is an act of imputing any person to lower down the dignity of that person by hacking his mail account and sending some mail with using vulgar language to unknown person, ठीक है. So basically that उस person का dignity खराब करने के लिए यूज़ किया जाता है. दिस इज डिफेमेशन. ओके, अनदर इज हैकिंग, वी ऑल आर फैमिलियर विद दैट. देन क्रैकिंग, विच मीन्स the stranger had broken into your computer system without your knowledge and consent. This is about the cracking. And then spoofing, a spoofed email may be said to be one which misrepresent its origin. Okay, and carding, which is a false ATM cards, and fraud, which we know, and threat, which we know, धमकी देना, है ना? हाँ जी. So let's go for the cyber crime against the property, which is going to be squatting, vandalism, hacking, virus, trespass. So let's read a little bit about this thing. Squatting means where two or more person is claiming for the same domain. ठीक है, that would be squatting. Okay. Vandalism about the destroying property of another person. वो भी जानबूझ के, डेफिनेटली सारी चीज़ें जानबूझ के किया जाए. हैकिंग अपन सबको पता है, वायरस अपन सबको पता है. ट्रेसपास मीन्स टू एक्सेस समवन कंप्यूटर विदाउट द राइट ऑथराइजेशन ऑफ ऑनर and does disturb, alter, misuse or the damage data or system by using wireless internet connection. So let's go for the cyber crime against the government, which is terrorism, warfare and the privacy. ठीक है, okay. अब मैं आपको बता दूँ, there was some question which was related to page number 319, same as it is. ठीक है, the various offences related to internet which have been made punishable under the IT Act and the IPC are enumerated below. You have to write these things. Cyber crime against the IT, which is hacking, tempting, publishing of offensive information, unauthorized access to protected system, breach of confidentiality is cyber crime under IPC and cyber crime under special act. So they were main point guys. ठीक है, इतना वैसे टफ तो नहीं है, एक बार रटना है, मैं सही बताऊँ, थोड़ा सा नाम रटना पड़ेगा आपको. That's it. ठीक है, now shall we go for the previous year question papers, जो कि अब start करते हैं. Okay, so let's go for it, the December 2024 first. Okay guys, let's not waste our time. Hope you are having the question paper. If you are not having the question paper, you can download it. I've already given the link for the question paper and suggested answer in my Telegram channel. ठीक है, आप वहाँ से डाउनलोड कर सकते हो. I'm going for December 2024 question paper first for the corporate law and economic law for the CMA final student. And let's go with the MCQ. You have to participate if you are there. मुझे यहाँ पे दिख रहे हैं पर कोई बोल ही नहीं रहा, पता नहीं क्यों नहीं बोल रहा. Okay, let's go for the question first. PQR Limited want to shift its register office from within the city limit. So if the company want to shift its register office within the state, ठीक है, in that case board resolution काफ़ी है. But in another case, if it is in another state, मतलब one state to another, they want to change. In that case, they have to take go for the special resolution and all. ठीक है, but this case it's going to be board resolution. So it's going to be B. In the parlance of the Companies Act, loan means a cash credit, not the short-term loan, not the long-term loan, not the working capital loan. ठीक है, so you have to mark it, this one. Okay, let's go for the company may remove a director through with what? Do you remember कि what were the section 167, 169 कौन सा था रे भैया, है ना? But with that ordinary resolution is to be passed, not the special resolution. याद करो guys, ठीक है, मैंने पढ़ाया था, कल ही पढ़ाया था. So the ordinary resolution of the shareholder is required to remove any of a director. Which rule of the company's appointment and the qualification of director rule 2014 provided the detailed procedure for making application for allotment of the DIN, that is rule number 9. Okay, let's go for this. आपको पता है मोस्ट ऑफ द क्वेश्चन तो अपने को पता ही होता है, बट कहीं बार गलत कर देते हैं अपन, ठीक है. एंड अब क्या है, MCQ फॉर्म आपको OMR शीट में फिल करना है एंड यू हैव टू कीप सम पॉइंट इन योर माइंड दैट शुड नॉट बी ओवरलैप्ड, है ना. ये गलती नहीं करने का. ओवरलैप मतलब मैंने एक को पहले किया, फिर मैंने उसको काटा, फिर मैंने दूसरे को किया, है ना, एनसर्कल, तो वो दोनों आपका 0 मार्क्स माना जाएगा. ओके, सो यू हैव टू मेक श्योर दिस पॉइंट. The insolvency professional proposed shall be continued rejected by the educating authority based on the information of IP to be sent by board. In the case none is proposed, the AA shall request for nomination within, do you remember, within 7 days, and the board shall nominate within further 10 days. Do you remember this point? Hanji. So let's go for 6.6 MCQ. Under IBC, the resolution professional shall file an application to the educating authority to extend the period of the corporate insolvency resolution process beyond the permit days if instructed to do so by the resolution passed at meeting of the committee of creditor, the vote of कितना voting power of the creditor 66, मैंने बोला था ये question आया है ना, तो it's important. Okay, COC का 66% of voting share is required in this case. Okay. The format for compliance report on the corporate governance by the listed entity has been specified to be submitted within the specified time limit according to Annex 4th has been submitted. अच्छा, they are going to be the report as per corporate governance. क्वेश्चन भी आया है इससे रिलेटेड है ना, वो अपन करेंगे, प्रीवियस ये क्वेश्चन पेपर में आया है. दे आर गोइंग टू बी Annex 4, ठीक है, 1 2 3 4. सो एज पर Annex 4 इट इज़ टू बी सबमिटेड ऑन हाफ ईयरली बेसिस. ओके, एक क्वेश्चन है वो अपन लेटर ऑन करेंगे ताकि अपने को और अच्छे से समझ में, वो है ऑलरेडी क्वेश्चन में. ओके, लेट्स गो फॉर द 8th क्वेश्चन. इन द कंटेक्स्ट ऑफ सस्टेनेबिलिटी रिपोर्ट द सेबी हैज रीयूज्ड द फॉर्मेट इन May 2021 for reporting ESG parameters called business reporting and sustainability reporting. It seeks disclosure from listed entities on their performance against the principle of national guidelines on responsible business conduct. Each parameter is divided into leadership and leadership which is यहाँ पे bracket में formal लिखा हुआ है, that is going to be voluntarily. Okay, and the essential indicators is going to be, which is latter, which is going to be mandatory. So here the question is about this part, which is formal, and what is it is going to be voluntary or mandatory. So the leadership which is formal is going to be voluntary, and the latter which is indicator which is going to be mandatory. So A is going to be answer here. 9th का let's go for SEBI has 3 functional roles into one body and they are quasi judicial, quasi legislative and quasi executive. Okay, so they are asking which of the following is not a function, that is C, quasi official. It's not, it's function. So for the purpose of Competition Act, question number 10 of MCQ, the turnover threshold for the individual company operating in India in combination is, guys, इसमें जो अपन को MCQ में दे रखा है ना, वो ABCD दे रखा है, that is wrong. एंड जितना मुझे पता है टर्नओवर शुड बी मोर देन 1000 करोड़ एंड एसेट शुड बी मोर देन ऑफ 450 करोड़. सो दे आर आस्किंग अबाउट द टर्नओवर एंड इन आंसर दे इज आई गेस ABCD, जो कि इनमें से गलत है. टर्नओवर शुड बी मोर देन 1000 करोड़. Okay, let's go for the other part. The insurance policy issued by the insurer shall not be questioned after 3 years. If it is questioned before 3 years, then definitely it could be, है ना, कोई रेमेडीज मिल जाएगा. बट इफ इट इज क्वेश्चन आफ्टर 3 years, no entertainment. Okay, so in case of life insurance and the motor accident insurance, the insurable interest must be present at the time of making the policy and at the time of making a policy. So in both the cases, life insurance and motor insurance, दोनों के केस में the policy it should be there while taking the policy and at the time of death or accident. So it's going to be C. C is going to be answer. The judicial authority under the SARFAESI. Do you remember who is going to be the regulatory authority here? DRT है क्या? Debt Recovery Tribunal है क्या? हाँ जी, ठीक है. Nor the district, nor the high, nor the SEBI. So let's go for the 14th part. The decision of the Cyber Appellate Tribunal can be appealed to whom? High Court. 60 days. याद है कि नहीं? हाँ जी, हाँ जी. So the cases under PMLA can be tried to whom the special designated court which is set up by this regard. So let's go for some of the question, guys. I'll be quick. Okay, so hope you are having a question paper with you. I'm going with section B and question 2. Gautam of Uttar Pradesh incorporated a one-person company in compliance to law. He appointed his brother Rohit as a nominee. Okay, both are resident Indian citizen. On 12/2/2024, Rohit left India permanently and to settle in Dubai and he has withdrawn the nomination. Okay जी, पहले तो उन्होंने अपने भैया को रखा which is Rohit, and then Rohit left the India and he settled in Dubai and he withdrawn the nomination. So you are required to answer the following in the light of the provision of the Companies Act. What action should be taken by Gautam when he get notice of withdrawal of the nomination and within what time limit? First. Second, Gautam want to appoint a minor son. So whether minor son can be appointed, अपने को पता ही है ना? So can Gautam appoint his minor son as a nominee in OBC? Examine with the reference the correctness of the same. And third, in case Gautam fails to appoint a new nominee, so what is going to be the legal consequences? So let's read, guys. So here the nominee can be appointed in case of death, incapacity of the original shareholder. ये अपने को पता है because the Gautam appointed this Roni, right, Rohit, right? So in this case the person was appointed, but within nominee shall give his the company shall within 30 days of receipt of the notice of withdrawal of the consent have to file that with to the registrar. And in what form number? The name of another person nominated by in form number INC 4 and the written consent of another person so nominated in INC 4. It's to be given to the registrar. Okay, but the continuation, let's go for the whether that person can be appointed, the minor son can be appointed here. No, the minor son cannot be appointed as a nominee here. And what if he do not go for any nominee here? So as per the law, they would be appointment of nominee for the perpetual existence. In case of failure to do so, the OBC and any of its officer of the company will liable for a fine which may extend up to 5,000. Okay, and it's going to extend further for 5,000 for if this is going to continue for per day. Okay, so let's go for the question next, which is of examine the provision of the Companies Act relating to the maintenance of the books of accounts in electronic form, which is under section 128. हाँ जी, so as per 128 rule अपने को पता है section 128 rule 3 of the company electronic mode में होना चाहिए, सब कुछ maintain होना चाहिए, ठीक है, alter नहीं होना चाहिए. So these are the main thing which we know, ठीक है. So I'm not going in depth, आप एक बार read कर लेना. अच्छा, what I'm going to read is जो most important है, अपन ने cover नहीं किए, ठीक है. Highlighted को मैं एक बार read करके चली जाऊँगी, ठीक है. Okay, this which is this question number 3rd. Brinda Limited is an unlisted company with paid up share capital 40 crore. Okay जी. Turnover of 350 crore. Okay जी. So what are they saying? They have the following top managerial person. Important है guys. सब कुछ important क्योंकि previous year question paper है. Mr. Rajiv Mishra, who is a promoter and a managing director of the company. Mr. Preetham is a non-executive chairman. Mr. Chandan Chandra, director, who is from finance. Mr. Anurag Sinha, director, operation, is related to promoter, and Mrs. Spruti, company secretary. The company is in a plan for expansion and therefore wants to avail seizable loan from the nationalized bank. Okay, the bank want to nominate a director in the board. So the MD seek your advice in the following point. Number first, is the present board properly constituted? If not, what is the non-compliance? Okay, and second, can Mr. Anurag Sinha considered as independent director? So let's see first of all the Anurag Sinha here. Anurag Sinha is a related person of promoter and a related person cannot be appointed as an independent director. पहली बात तो ठीक है. So what will the status of director if the nominated by bank? Okay जी, nominated by bank के लिए कुछ चीज़ें होती है. Okay, if the said nominated director is a woman, what should be satisfy the requirement? Do you remember women director के लिए what is going to be the requirement? Paid up share capital should be of 100 crore or more, or the turnover should be of 300 crore or more. Yes, and with that, is there any requirement of CFO? Do you remember key manager person 200 and कौन सा वाला section था guys? 203 वाला section था, rule 8 वाला section था, and 10 करोड़ से ज़्यादा paid up share capital होगा तब then they are required. In this case they are having more than 10 crore which is paid up share capital of 40 crore. ठीक है, so yes, you are required to advise the MD suitably. So let's go for it very quickly guys. First of all, we know the limit for the paid up share for the women director 100 crore 300 crore paid up turnover. Okay जी, हाँ जी. So here the company unlisted with 4 director which is properly constituted, and a public company will require to mandate appoint at least 1 director if it fulfill any of the following condition जो कि हो रहा है 100 crore 300 crore. Okay, Let's go for the second, the key manager person, where he cannot hold that company because he is a relative of that promoter, है ना. So independent director नहीं हो सकता. The relative of the independent director should not hold the position of key manager person. Mr. Anurag Sinha is a relative of MD. Wu is an otherwise KMP. Hence, he cannot be appointed as the independent director. Okay, ji. Number third point is he and she will be classified as nominee director. Yes, she will be considered to fulfill the requirement as per Rule 3 of the Companies Act for the Rule 2019. And yes, 203 के हिसाब से, Rule 8 के हिसाब से, every listed company and every other public company having a paid up share capital of 10 crore or more shall have a full-time director, key manager person. So this, there they can appoint him. ठीक है. So this is the main point, जो कि अपन को पता है. इसमें से 2 सेक्शंस कवर हुए हैं, ठीक है, विच वॉज दी वुमेन डायरेक्टर की, ठीक है, एंड 203 वाला की मैनेजर पर्सन के. ओके, सो यू हैव टू मेंशन दैट द क्वेश्चन नेम, द क्वेश्चन नंबर एंड व्हाट इज इनसाइड, वो सब कुछ बताने का है. लेट्स गो फॉर द डाटा प्रोटेक्शन अंडर द इंफॉर्मेशन एक्ट, थ्रो लाइट ऑन द डाटा प्रोटेक्शन एक्ट. So what is that? ये अपने को पता है, where जब privacy, it refer to the set of privacy law, policies and the procedures and one's privacy. Actually main aim is to minimize one privacy which is related to collection, storage, dismantling of the personal data. ठीक है. So this is the एक second guys, it's हाँ. So let's go for the other page. Hope so you are also referring the question paper, the suggested answers with you. The important provision, another page on third, ठीक है, which is related to IT sector of data protection, where such body corporate shall be liable for the damage to the person so affected, and the punishment would be imprisonment and of 5 lakh and the imprisonment of 3 years and the fine of 5 lakh or both. ठीक है. So hope so this part was clear to you guys. Let's go for the question number 4th, which says about the under such section 28 of IBC 2016, the resolution professional will have to take a prior approval. Yes, do you remember what were the section 28 was saying that they have to take the prior approval, right? Raise the interim finance, create any securities वाला, remember ये सारी चीज़ें जो कि अपन कर चुके हैं, ठीक है. That is, देखो सीधे सीधे क्वेश्चन आ चुका है, आपको कोई घुमा के यहाँ पे क्वेश्चन नहीं पूछ रहा है. So we have to go through each and every point guys. What is meant by corporate governance? Yes, we know, ठीक है. So how are the listing entities required to submit periodic report on the corporate governance? So do we know about the corporate governance guys? अपने को तो बहुत अच्छे से पता है ना what is the meaning of corporate governance. Okay, it refers to how the corporate monitors the corporate policies, the corporate procedure and action which is to be taken. Okay, now let's go for the report as per SEBI. As I told you, annex 1 which is to be sent on a quarterly basis. Okay, the report is to be submit quarterly basis, and that is of commission of board of directors, a composition of committee, the stakeholder committee, meeting of the BOD and all. ठीक है. With that, annex 2 state about the report which is to be submitted at the end. पहले वाला quarterly, second वाला end of the financial year, third वाला end of 6 month from the closure of financial year. 6 महीने from the end of closure of financial. Quarterly, second is going to be end of financial year, third is going to be end of 6 months from the close of financial year, and fourth loan or guarantee given. ठीक है. Okay, and this was all about this part guys, and with this annual report is to be submitted, which submit the quarterly which is to be compliance with the regulations and all. Okay, let's go for the other part which is 5th. Examine the importance aspect related to due diligence and the various aspect to be seen in context of evaluation of CSR project. अपने को तो CSR के बारे में पता है, but do we know about the this point which is saying about the due diligence? So what is this? Let's understand a bit. This is an investigation and a verify an entity where investigation is done before initiating the business arrangement with the entity. So whatever the investigation is done before, okay, where initiating, just before initiating the business arrangement with the entity, that is going to be due diligence. So here the evaluation is done on basis of 2 part. I have differentiate on the basis of 2. ठीक है, I have नहीं, actual में वही है. ठीक है. So by making the evaluation before making the expenditure and after making the expenditure. So if it is done before making the expenditure, that is going to be due diligence. And what are the thing which is going to be done, what is the purpose, whether the company is ultimately taking up the project and making the expenditure, is what due diligence saying. So what are some of the points which is going to be covered? The nature of project, the cost of project, the implementation time, the financial feasibility, the technical feasibility. These are the things which is going to be covered here. Okay, we know corporate governance, but we don't know due diligence. This was a new point, guys. Okay, let's go for the other point, guys, which is related to fifth का B, fifth question का B. क्वेश्चन पढ़ते ही याद आना चाहिए कि कौन से सेक्शंस हैं यहाँ पे. ओके, अ कंपनी, अ पब्लिक लिमिटेड कंपनी हैज़ 600 मेंबर, द इशूड एंड द पेड अप कैपिटल इज 5 करोड़, कंसिस्टिंग ऑफ 5 लाख, इक्विटी शेयर ऑफ 100 each, 90 member holding 10,000 equity share file a petition before tribunal. ओके, सेक्शन 241 है क्या? हाँ जी. वो एलिजिबिलिटी कौन सा वाला सेक्शन था? 244 है क्या? हाँ जी. ओके जी, ओके जी. ठीक है. फॉर द पर्पस ऑफ रिलीफ अगेंस्ट द ऑपरेशन एंड मिसमैनेजमेंट बाय द मेजॉरिटी शेयर होल्डर्स. ओके, ये भी समझ में आता है. इन द लाइट ऑफ द अबव आंसर द फॉलोइंग, एग्जामिन द रिलेवेंट प्रोविजन ऑफ द लॉ and decide whether the said petition is maintainable. Okay, so what were the eligibility under section 244? We have to read with section 241 and what are they saying, है ना? Do you remember, guys? Yes. हाँ. So do you remember the point where 100 member or 1/10 of total number of member or one or more member who is holding 1/10 of total issued share capital, and they have given issued share capital, the total number here is 600, so 1/10 is going to be 60 and the number of member is here is 90 who is holding 10,000 equity shares. ठीक है, so is it going to be applicable? 90 is more than 60, right? And here the paid up share capital is going to be 5 lakh equity share. तो 1/10 उसका निकालने का है ना? So yes, they are falling under the condition. So they are going to be 2 section along with 241 के साथ साथ 244, remember, है ना? Okay. So application to tribunal with that. So and second is going to be in the case 40 members subsequently withdraw their consent, what will happen to the petition? Is this going to be applicable continuing the application? हाँ जी, whether they are going to withdraw the application, उससे कोई फ़र्क नहीं पड़ता. राजा मुंद्री इलेक्ट्रिक सप्लाई कॉर्पोरेशन वर्सेस नागेश्वर राव लिमिटेड, याद है क्या? हाँ जी. That is going to be applicable or not, withdraw करो नहीं करो, the application will still go on. ठीक है, that was this point saying. Let's go for the third point, which says in case of the total number are less than the required, is it possible to file a petition? Yes, if the NCLT decides to, then only. ठीक है, so this was all about this part. Let's go for the sixth point. Describe the insider trading as regulated under SEBI, prohibited of insider trading regulation 2015. What institutional mechanisms are to be placed by the listed company to check, control and curb insider trading? So we have to describe insider trading. अब insider trading, do you remember? इतना लंबा चौड़ा मैंने definition बताया था, insider का बताया था, insider के लिए बताया था, insider trading के लिए बताया था, unpublished price sensitive information, ये सब बताया था, है ना? ये सारे चीज़ें याद रखनी है, तभी अपन लिख पाएंगे ना, है ना? So here let me read it. थोड़ा सा definition. Insider trading, also known as insider dealing. Insider dealing, yes, is the malpractice of selling or buying securities such as equity and a bond by the insider of the company, which include the employee, directors, executive and the promoter. So yes, ठीक है. With that, what is going to be the institutional mechanism for preventing? Chief Executive Officer, the Audit Committee, BOD, remember, हाँ जी. And every listed company shall formulate the policies and the procedure for the investigation, inquiry, and with that the listed company shall go for the whistleblower policies. And if any inquiry has been initiated by the listed company in case of leak of unpublished price sensitive information, that the relevant intermediary and the fiduciary shall cooperate with the listed company. So these are the point which is to be written. ठीक है, अपन को अगर पता ही नहीं होगा तो we cannot write दिस आंसर एंड दिस वॉज सुपर ईजी, पता है, इसलिए मैं बोल रही थी इनसाइडर ट्रेडर के लिए एक बार देखो. लेट्स गो फॉर व्हाट इज द सेकेंड पार्ट ऑफ दिस क्वेश्चन 6B. What is understood by the abuse of dominant position as per the provision of the Competition Act? अब dominant position का मतलब क्या है? Taking the advantage, monopoly करना, है ना? So this is all we have to write. Imposition of unfair and discrimination of price, ठीक है? So this is related to Competition Act, ठीक है? You have to write it, guys. Let's go for the other part, which is related to state the provision of Banking Act. नहीं, there is one more point, I guess. कहाँ है? डोमिनेंट पोजीशन हो गया है, पता नहीं इसमें क्या लिखा हुआ है. Okay, let's go for the state the provision of Banking Regulation Act, okay, which is related to disposal of non-banking act. Do you remember this point? सेक्शन 7 था, है, सेक्शन 9 था, एंड विद दैट सेक्शन 6 था, है ना, दैट नो बैंकिंग कंपनी कैन कीप द नॉन एसेट फॉर मोर देन 7 years, रिमेंबर, है ना, एंड with the prior approval of the RBI they can do it. The extension can be possible for 5 further years, ठीक है. So it should be used for its personal use, for the own use. No other person or any other entity should use that, है ना, नॉन एसेट, ठीक है. सो दिस इज ऑल अबाउट डिस्पोजल ऑफ नॉन बैंकिंग एसेट. एज इट इज क्वेश्चन आ गया है ना, कुछ घुमा के तो नहीं आया है ना, नहीं. सो लेट्स गो फॉर द अदर पार्ट. स्टेट द पर्सन एलिजिबल टू क्लेम द बेनिफिट अंडर लिबराइज रेमिटेंस स्कीम. पढ़ाया था क्या मैंने, बोला था क्या मैंने कि इंपॉर्टेंट है. रिमेंबर द रेजिडेंट इंडिविजुअल इंक्लूडिंग द माइनर USD 250, रिमेंबर, हाँ जी. सो दिस इज़ ऑल अबाउट दैट पार्ट, ठीक है, एंड इट्स सुपर इजी गाइज. इनफैक्ट इसमें तो और भी ईजी तरीके से लिखा हुआ है ना. सो यू हैव टू गो थ्रू इट. एंड विच वॉज ऑफ 2,50,000. डू यू रिमेंबर? इमिग्रेशन, मेडिकल और वो स्टडीज से रिलेटेड हो तो इफ़ द अप्रूवल द ऑथराइज अथॉरिटी इज गिविंग द डॉक्यूमेंटेशन, इन दैट केस नो नीड to go for the limit. They can cross the limit of $250,000 USD dollar, ठीक है. So with that there are some other key for the other than individual claim what is going to be in case, ठीक है. You have to write this thing, guys, ठीक है. Let's go for the 7th question of the second part. State the offense of money laundering listed in different schedule under PMLA Act. Do you remember part A, part B, part C, ठीक है. पार्ट ए पार्ट बी के लिए मैंने बोला था तब भी, टू नो पार्ट बी यू हैव टू नो अबाउट द पार्ट ए फर्स्ट. वॉट एवर द acts are written in part A like narcotic substance and all, ठीक है, that is going to be covered in part B if the amount involved is more than 1 crore, ठीक है. and with that part C is going to be the trans border crime, ठीक है. so this you have to define, but with that you have to write a little bit about the money laundering first of all, ठीक है. okay, so let's go for the other part of question 8. all dues of MSME vendor have to paid in time. This I already mentioned while I was teaching you about the MSME वाला, ठीक है. लास्ट मैंने इसके बारे में डिस्कस किया था. इन केस ऑफ डिले इन मेकिंग द पेमेंट वेयर there will some of disallowance on the interest payable to be made by the buyer under the Micro, Small, Medium Enterprise Development Act 2006. You are required to throw the light on the same. What are the disclosed in the financial statement? Okay. So the buyer have to make a payment within 45 days of issue of invoice. हाँ जी बोला था, हाँ जी. Okay. So what if the buyer is unable to make a payment within that specified time limit? Then they have to pay the interest rate which is determined by RBI, and that is going to be thrice of the interest rate. Okay, and with that the income tax disallowance would be there under section 43B. Remember, हाँ जी. and everything is to be mentioned in the financial statement. मतलब reporting should be made in the financial statement, and the principal amount of interest due to the supplier is to be mentioned. The interest paid by the buyer to the supplier is to be mentioned, and tax auditor to report to amount of interest inadmissible under section 23 is to be again mentioned there, ठीक है. so they are the thing which we have to mention. अगर आपको इसके बारे में एक भी नहीं पता आप कुछ नहीं लिख सकते, and this is the easy question. अगर नहीं पता तो कहाँ से लिखोगे, है ना? So yes, discuss about the, and मैं आपको बताता हूँ सेम यही question इससे previous attempt में भी आया है. This is of December 24 ना, I guess June 24 में भी was also a question. Discuss about the amalgamation of the central government on public interest as per provision of the company. Do you remember? Where I already told you about the amalgamation of this part. The central government can go for that, ठीक है, of 2 or more company by issuing a notification or official gadget. Do you remember section 237? ठीक है, so this is all about this part where the right and the all of the compensation should be given, है ना, to the members and the creditor of the transferor company to transferee company, to transfer company to one or more transferee company. Remember, है ना? So simple question आया है, बिल्कुल ही simple उन्होंने पूछा है, ठीक है, इसमें कुछ भी difficulty नहीं थी guys. Let's go for the another question paper of June 2024 attempt. I'll be quick again guys. Okay, as per syllabus 2022 we are going. Hope you are having the question paper. If you are not having, please download it, ठीक है, आपको लिंक आराम से मेरे टेलीग्राम चैनल पे मिल जाएगा क्वेश्चन पेपर का भी और सजेस्टेड आंसर्स का भी. ओके, लेट्स गो फॉर इट. ABC Limited has 35% share in XYZ Limited. The majority of director of XYZ Limited are appointed and removed by the ABC Limited. So it's having, the ABC is having the share in XYZ and it's 35%. The majority of shareholder of XYZ are appointed and removed by ABC. हाँ जी. So here XYZ Limited is what? The subsidiary company. Okay, हाँ जी. The paid up capital required in public company in which the number of independent director at least 2 is going to be 10. Remember 10, 100, 50 paid up share capital, turnover and outstanding वगैरह remember है. Okay, so as per Companies Act in certain, ये रहा वो वाला question which is related to small shareholder. 151 section था क्या guys? Okay, as per Companies Act 2013, a certain company director may be appointed by a small shareholder. Small shareholder means a shareholder वो hold a share worth of face value of maximum बोला है, ठीक है. अपन ने क्या पढ़ा था, which should be less than 20,000, so it should be, the maximum amount is going to be 20,000 of nominal value. Remember? Okay, so here they have given 20,000 maximum. So it's going to be answer C point. Let's go for the next point, fourth question. Sorry. In case of open offer by the public company to its shareholder, the type of bank account where the amount payable to shareholders are kept in escrow account, and that is actually opened by some other third trustee party where 2 of the parties are going to do their transaction. Okay, so let's go for the 5th point where XYZ Company Limited was incorporated on 1st of April 2023. It's a paid up capital of 10 lakh consists of 1 lakh equity shares, 10 each, held by 100 individual. There are 6 director in its board. The quorum of its general meeting, it's going to be what? Guys, you have to decide. ठीक है, quorum के लिए what I told you, I'm not going to tell you again. Strength के लिए नहीं, quorum के लिए, ठीक है. 2 or 1/3 था क्या? Guys, do you remember? So you have to tell this because I'm not going to tell you this point. Okay, so let's go for the 6th point. The board of director of the limited company wants to cooperate and export in specialized field. In this context, the correct option we have to decide. Number 4 says the tenure of the expert director shall not exceed such period as may be specified in the articles, है ना. Okay, an additional director can be appointed exceeding 1/5 of total number of director. ऐसा कुछ है क्या? अपन ने तो कुछ पढ़ा ही नहीं, गलत है ये. The tenure of the expert director shall not exceed 1 year. ऐसा तो कुछ भी नहीं है. Then the expert director can be appointed exceeding 1/5 of total number of director. ऐसा भी कुछ नहीं. So the first point is right. The tenure of the expert director shall not exceed such period as may be specified in the articles. Okay. Let's go for the 7th point. Under the IBC, the corporate insolvency resolution process shall be completed within a period of, do you remember पहले 90, then 180, then 330. So yes, it's going to be 180. Remember? हाँ जी. Okay, let's go for the 8th क्वेश्चन विच इज दे आर 3 अप्रोचेस टू सस्टेनेबल मैनेजमेंट. इतना पढ़ो ना, आपको पहले से ना चीज़ें आ जानी चाहिए, क्या क्या चीज़ें हो सकती है, व्हाट इज गोइंग टू द पॉसिबिलिटी हेयर. सो नंबर फर्स्ट इकोलॉजिकल अप्रोच, एग्जैक्टली. इकोलॉजिकल एंड एनवायरमेंट अप्रोच, एग्जैक्टली. द सोशल अप्रोच, हाँ जी, तो 3 अप्रोच तो यही है. सो बट अबाउट द 4, ergonomic approach is not approach in the sustainable management. So this is the incorrect one. ठीक है, this is not the part of 3 approaches here. Okay, D part is wrong. मतलब D part is the answer which is not the part of the sustainable management. Let's go for the 9th. Amalgamation of banking company requires approval of two-third of its shareholder. Okay. 10th says above where the application of merger is submitted to CCL demand, deemed approval may be presumed. If no approval is received within 180 days, then in that case only it's going to be deemed approval, it's going to be presumed. What's about the 11th question? In case of listed company, minimum subscription, do you remember मैंने बोला था ये question MCQ के फॉर्म में है. As per SEBI regulation is 90% of issue size. Yes, that is going to be a big answer here. 90% of the ticket size here. Okay, so business, let's go for the 12th part. 12th question. Business intelligence tool which put BI and the data visualization functionally directly into business application is called the embedded BI. इसको अपने को रटना पड़ेगा guys, इसमें मैं कुछ नहीं कर सकती. Let's go for the other point. Okay guys, MSME का वो है criteria revised, so you have to go for the new one, not the old one. Let's go for the 14th here. The insolvency and bankruptcy code has a power of civil court, not the criminal, not the high, not the session. It's going to be civil. Okay. As per IRDA Act 1999, the minimum paid up capital requirement for the registration of life insurance, general insurance and the health insurance going to be 100 crore. Okay, okay, let's go for the section B guys. So here सीधी क्वेश्चन आया और मैं इसके बारे में पहले ही बोल चुकी हूँ. क्लास एक्शन, व्हाट इज गोइंग टू बी क्लास एक्शन अंडर सेक्शन 245. ओके, एंड व्हाट आर गोइंग टू बी रेमेडीज. इंटरेस्ट ऑफ द कंपनी एंड डिपोजिटर वाला, रिमेंबर. ठीक है, व्हाट इज गोइंग टू बी रेमेडीज ये भी अपने को पता है. आई एम नॉट गोइंग इन डेप्थ गाइस. ठीक है, सो येस यू हैव टू लुक इनटू दैट. सीधा सीधा क्वेश्चन आया है ना. एंड गाइस डोंट लीव एनी पार्ट बिकॉज यू नो कहीं बार क्वेश्चन बिल्कुल सेम आ जाते हैं, बिल्कुल सीधी सीधी चीज़ आते हैं. दे आर नॉट गोइंग फॉर एनी केस स्टडीज एंड ऑल. ठीक है, ना ही कोई क्वेश्चन इसमें था. सो वो आर अ पर्सन नॉट entitled to initiate the insolvency resolution process. Do you remember who is going to be this person undergoing insolvent? ऐसे था क्या, who have gone for this the insolvency resolution process and 12 months have not been completed, or the corporate debtor of the financial creditor have violated any rules. Remember, हाँ जी, यही सारी चीज़ें. Let's go for the other part guys. The third question, what is the quorum of the company board meeting in the following cases? Again the quorum as per section कौन सा था quorum? Quorum 174 था and 1/3 of the total strength था, and 1/3 of total strength means the vacated it's not going to be included here in case of total strength, right? So a public company has a 10 director including 4 non-executive director, but 8 director including 4 non-executive director attending the BOD. So here 10th का 1/3 is going to be what? 1/10. Let's take. That is going to be 3.33. So we are going to take 4 quorum. Okay, so the quorum is going to be 4. We have to make the fraction round here. Okay, so let's go for the second point. Just we have to write down the quorum here. ठीक है, number of the directors. ठीक है, who is going to attend the meeting. ठीक है, बस उतना लिखना है. As per section and कितने होंगे बस उतना लिखना है. अगर आपको पता है it's very easy, नहीं पता तो सीधे सीधा मार्क्स गए क्योंकि आपने अटेंड नहीं किया, आपको आता ही नहीं है. लेट्स गो फॉर द सेकंड पार्ट. द स्टार्टअप ओडिशा लिमिटेड इज अ सेक्शन 8 कंपनी. फॉर सेक्शन 8 कंपनी 25% ऑफ टोटल स्ट्रेंथ और 2 नंबर ऑफ ऐसा कुछ आ गया. हाँ जी, तो लेट्स गो फॉर 8 का 25%. As per the question, Startup Audit Limited is the Section 8 company which has 8 non-executive director and 3 directors are attending this meeting. So here 8 का 25% is going to be what 2%, ठीक है, okay, and 3 are, and second option what was that, 2 director should be there, or 8 का 25%, and if they have what financial statement annual return file किया, ऐसा कुछ था क्या इसके बारे में, do you remember? If you remember comment, ठीक है. So yes, they are 3 director who are attending the meeting, so definitely they have fulfilled the quorum. Let's go for the third point. BOD of X Limited consists of 9 executive director and 3 non-executive director. Total 6 executive director and 3 executive director have, the non-executive director have attended the BOD. A business was transited in which one director was interested. So they are total, let me say, they are 12 in number, right? So total quorum should be at least 4. So as per this, how much they have attended? 6 executive have attended and 3 non-executive have attended. मतलब total in 9, और उसमें से एक interested भी होता है तो कोई दिक्कत नहीं है. So total 8 they have attended, and quorum which is 4, so which is more than 4, ठीक है. So that quorum is right, ठीक है, applicable है, कोई दिक्कत नहीं है इसके लिए. Let's go for the other part. State the restriction on dealing in the foreign exchange. The question third का भी, okay, and holding a foreign exchange or the foreign securities. Do you remember the point? There was some point which was saying about they cannot hold any of the asset in form of these things, ठीक है, but they could be like in form of inheritance, gift, ठीक है, या फिर RBI से approval ले लिया गया है ना, or if the property was purchased out of the resident foreign account, DRFC account, ठीक है. So these are the cases where they can go for that, ठीक है. Okay, let's go for the fourth point. Again CSR के बारे में question आ गया है, सीधा सा part, if you know, and that is in form of case study guys. So RR Limited is a public limited company having its registered office in Bangalore and has been exercised since March 2010. Okay, the following is summarized position of its financial statement, and you have to go for the net worth guys, and the turnover and the net profit, and what were the criteria under section क्या था, 135 था ना, हाँ जी. So for that net worth should be कितना, 5 करोड़ और क्या वो तो नेट प्रॉफिट था, ठीक है. गो फॉर दैट. नेटवर्थ वॉज ऑफ 500 करोड़, टर्नओवर वॉज ऑफ 1000 करोड़ एंड द नेट प्रॉफिट ऑफ 5 करोड़. अगर द कंपनी इज गोइंग थ्रू एनी ऑफ दिस क्राइटेरिया, is falling under any of the criteria, then they have to go for CSR activity, they have to contribute toward that. And for the average of 3 preceding financial year of what, 2%, ठीक है. So here they have to take, does the company comes within the preview of the CSR? Let's see. Yes, as per the net profit they are falling, ठीक है. So is the second part says, is the CSR committee required to be formed? Yes. What will be the minimum budget for CSR compliance? They are asking about. So you have to write it guys. 2% of the average profit is going to be there. And fourth, what are the other CSR obligation under the provision of the Companies Act 2013? That amount to be spent before the end of financial year, and with that the detail of CSR spending have to be furnished to report of BOD for from form CSR1, and it is to be filled, ठीक है. So this you have to keep in your mind. Okay, let's go for the other question guys. Question fourth का being the board of director of the McKinsey Limited, a listed company, appointed Dinesh as an executive director at a BOD, at board meeting, on June 1st, 2023. The company took up the appointment of Dinesh for the approval of shareholder at its annual general meeting held in September, but the same was not approved by shareholder. Number first, if the board of director have appointed the additional director, whether they have to take the approval from the shareholder in next AGM. Do you remember ऐसा कुछ था? हाँ जी, ऐसा था. Okay, let's continue. However, he was appointed as additional director on a full-time employment by the board at its meeting held on September 30, 2023 by passing a resolution to hold the office of the directorship till the conclusion of the next AGM. To be held for the year is appointment of Dinesh for an additional director by the board justified. Now do you remember what was the section of additional director? जल्दी बताओ, एडिशनल डायरेक्टर का सेक्शन क्या था? 161 सबसेक्शन 1 था क्या गाइस? कुछ भी याद नहीं है अपन को. वेरी गुड. So as per this, the board can appoint any person other than person who fails to be appointed as a director in general meeting. Okay, so here the board have appointed Mr. Dinesh as an additional director. Okay, इतनी भी बात समझ में आ गई. But at any time who shall hold office up to the date of next AGM or the last date on which the annual general meeting should be held, whichever is earlier. He can hold up to that time. But a listed company shall ensure all the approval of shareholder for the appointment of a person on the board of a company as a director or manager is taken at the next general meeting or within the time period of 3 months from the date of appointment, whichever is earlier. So here they have to take the approval from them. ठीक है. Earlier rejected shall be appointed with the approval of the shareholder. If the approval of shareholder is not given, then that person cannot continue. Let's go for the fifth question. Again insider trading का question है. अब guys ये दिमाग घुमाने वाला थोड़ा सा question है, because as per the provision it's going to be insider trading or not, we have to decide, and there is one case study which says opposite of this part. ठीक है, let me read it. A PASU awarded 2 contract, one in favor of Government Infrastructure Project Limited and the another in favor of Simple Infrastructure Limited. Ranjan was the CMD of GIPL at the time of award of contract, and GIPL and SIL has entered into 2 shareholder agreement which were terminated later on by GIPL vote. Ranjan sold the shares of GIPL before it was intimated to the National Stock Exchange. SEBI charged the Ranjan as guilty of insider trading, and however Ranjan took a plea that it was necessary as a part of corporate reconstruction to prevent the GIPL parent company from going into bankruptcy. Okay, which was the factfully found to be corrected. Then you have to examine, is the Ranjan an insider in this case, what is his liability in any, and second, what is the meaning of unpublished price sensitivity information, जो कि मैं 100 बार बोल चुकी थी क्लास के टाइम पे. Okay, and third, are the changes of SEBI, are the charges of SEBI correct? So first of all, we have to understand this Mr. Ranjan is going to be the insider or not. Yes, who is or have a connection with the company or is going to be have a connection with the company. ठीक है, who have access, who can access the price, the information which is related to UPSI, unpublished price sensitive information, and if that UPSI is the information related to UPSI is given to any other person, to the outsider, then it's going to affect the price of the security price, okay, of the company. Okay, so this is what this about, and what are the things which is going to be under UPSI, like the matter related to merger amalgamation, the financial statement, financial return, and the dividend which is related to interim or the final. ये सारी चीज़ें होती हैं. So now you have to tell me whether this person was an insider. Yes, Ranjan was an insider. ये तो बात अपने को समझ में आ गई. But there was this is going to be insider trading or not is going to be another question. But as per there was a case study, ठीक है, वो says about the SEBI versus Abhijit that this Ranjan is not have not done anything wrong, because that was done just in favor or to save the company, right? The company was going into bankruptcy. That's why any of the charges made by the SEBI cannot be correct here. So वैसे देखा जाए, so this is the case of insider, he is an insider and it's a case of insider trading. But there is a case saying which is in favor of this person Ranjan, and that is SEBI versus Abhijit Ranjan. ठीक है, so here they are saying the SEBI is not correct. ठीक है, तो मैं बोल रही हूँ आंसर घूम गया. ओके, तो ये चीज़ें भी हो जाती है कभी कभी. Mr. Paras, next question, fifth का भी, Mr. Paras deal with the company in a manner incompatible with some of the article mentioned in the article of association. What will be the consequences of the same? Is there any exception? Do you know this is related to doctrine of the construction notice, है ना? So and exception is going to be there, forgery ये जो सा है ना. So these two you have to read, जो मैं अभी बता चुकी हूँ आपको. Just read it guys. Okay, what do you mean by business intelligence? Okay, in the context of the cyber security, what are its benefit? We just read. ठीक है. Okay, speed up कर लेता है, improve decision, increase operational efficiency, productivity and all. Okay, These were the main point. Let's go for the B question of 6th part. Discuss about the power of the Competition Commission of India in order to division of the enterprise enjoying the dominant position. Do you know what are that? Yeah, let me read it. ठीक है, as per question number 6, page number 6 of the law 2024 June attempt. The transfer of vesting of property, right, liability and obligation, वैसे अपन पढ़ चुके हैं, but still I am going to read. Then the adjournment of the contract, the creation, the allotment, the surrender or cancellation of any share, stocks or securities, formation of winding up of enterprises or amendment of memorandum of article of the association. All it's the main power of the Competition Commission of the India. Okay, Hanji. So let's go for the other point, which is briefly explain the process of the money laundering. सीधी question पूछा गया है. बिजनेस इंटेलिजेंट भी क्वेश्चन सीधा था, ठीक है. कंपटीशन कमीशन से रिगार्डिंग भी इजी था, है ना. एंड दिस इज अगेन मनी लॉन्ड्रिंग का केस. डू यू रिमेंबर कौन सा? प्लेसमेंट, लेयरिंग, इंटीग्रेशन, यही था ना 3, है ना. विद दैट पार्ट 3, पार्ट ए, पार्ट बी, पार्ट सी ऑफेंसेस, है ना. सो विद दैट यू हैव टू मेंशन दैट ऑल्सो. Let's go for question number 7, which is about the principle of indemnity and subrogation. Do you remember I already told what is about the indemnity? You cannot, the insurer cannot recover the amount which is, he can only recover the amount of loss, up to the loss. He cannot go for the more of the amount, right? And what about the subrogation? What if the party got the recovery, the insurance amount from the insurance company, and in future which was related to motorcycle, okay, and the motorcycle was taken by any other person and it was recovered later on. Now the party can take that motorcycle. No, he have taken the amount from the insurance company, so in this case he cannot go for that. The control is with the insurance company here. So this is about the indemnity and subrogation. So what are the loan restriction on loan? What are the restrictions on loan and advances by bank as advised by the Banking Regulation Act? Guys, अपन ने ये वाला क्वेश्चन भी पढ़ा है या नहीं पढ़ा? That was the purpose, the margin, the interest rate, the guarantee, the advances given and all maximum. That is to be written. ठीक है? This about the section 20 and section 21. Next go for the question number 7 का C. State the limit line, time limit for the payment to make the buyer to MSME and consequences of delay in payment to them. 45 days बोला था, हाँ जी. Remember disallowance हो जाएगा, हाँ जी. And interest rate is going with rise of notified by RBI, right? हाँ जी. And with that, what one more thing कि it should, you have to disclose in the financial report everything, right? This was all about same question ही था ना जो अपन ने पिछले अटेम्प्ट में, जस्ट पिछले अटेम्प्ट में देखा था, हाँ जी. सो लेट्स गो फॉर द अनदर क्वेश्चन विच इज क्वेश्चन नंबर 8. शुड इन्वेस्टमेंट ऑफ द लिमिटेड कंपनी बी हेल्ड इन इट्स ओन नेम? येस. स्टेट द रिक्वायरमेंट ऑफ द कंपनीज एक्ट. ये अपन ऑलरेडी पढ़ चुके हैं गाइस, है ना. इट शुड अंडर सेक्शन 187 with all of the investment made by held by the company in property, security in another asset shall be made held by its own name. The company cannot take any other name or any other person's name. So everything should be done in name of the company. Okay. So let's go for the question number 8 ka B. Discuss the sustainability report in light of need of filing of annual business reporting as per SEBI guidelines. Okay. So in this case, they have mentioned about 2 principles. Pehla principle which is related to do you remember the principle of the sustainability report? Integration, equity, intergeneration, sustainability से related everything which impact should be written, है ना, should be kept in mind, and the consequences should be kept in mind, whether these are properly utilized and stored for the future. I already told you. But with that, there are one more thing, one more principle of the national guidelines on reporting business is also coordinated with that. Do you remember there were 9 principles? मैंने कहा था let's coordinate between them. The ethically, accountability and the transparency. Do you remember we have already correlated this, ठीक है? Safe and sustainable of goods and services. Remember? Employees के लिए, customers के लिए, remember? So all the 9 principles and this principle should be maintained. And with that, this is saying that the apply of this principle, business need to be sensitive to characteristics such as caste, creed, sex, race, ethically, age, color, religion. तो लास्ट में जाके उन्होंने थोड़ा कॉर्पोरेट गवर्नेंस का पॉइंट ऐड किया. So this was all about this section guys, this part, and this question paper is over. ठीक है, मैं इतना डेप्थ में नहीं गई because most of question are सीधा सपाट question. Okay, so if you know the provision for solving, you can go for the answer. If you don't know, then you cannot. Okay, so let's go for the other question paper guys, which is of December 23. Okay, let's go for it guys. December 23, this is as per syllabus 2016 guys, है ना, please note it. So I am going for this part. Which of the following is not the benefit of CSR program? Let me read it first. The mutual trust, attracting and retaining employees, communities as supplies, enhancing corporate reputation. The first, which is a mutual trust, it's not the part of CSR. Second, the central government may remove from the office of the president, chairperson or any other person member of NCLT. वैसे ये अब अपना क्वेश्चन नहीं है, ठीक है, वैसे दिस इज नॉट इन अवर सिलेबस नाउ, ठीक है, NCLT. Let's go for the third part. The insolvency and bankruptcy code does not cover. This is again none of the option is there. They are saying the financial institute they cover, the insurance company they cover, mutual fund they cover. Basically they do not cover anything. ठीक है, okay, so none of above is the answer. Let's go for the fourth point, fourth question. The company shall furnish to the registrar verification of its registered office within a period of 30 days from the date of its incorporation. Okay, let's go for the fifth question, which is which of the following is not correct manner in which the name of any change in its particular as stated in form number 3, director DIR 3, an applicant intimates such change to the central government within period of 30 days of such period, such change in form DIR 3, where the applicant shall download the form which is DIR 6 from the portal. Number first is this. Number second, the form shall be digitally signed by a CA, CS, CMA, and then number third, the applicant shall submit the DIR form 6. Okay, so here the C point says the application shall submit the fees. Okay, this is not the correct one. Okay, let's go for the 6. The quality of something which enable one to understand the truth easily. In this context of corporate governance, it implies an accurate, adequate and timely disclosure of the relevant information about the reporting, operating result, etc. of the corporate enterprise to stakeholder. This principle is known as transparency. Okay, okay. Any allotment of the security made on the basis of prospectus should be void if permission of listing is not granted by security exchange before expiry of 10 week of the closure of issue. It's the answer here. Every banking company, this is 8th question, every banking company incorporated in India shall prepare a balance sheet P&L on the last working date of what? The accounting year. Remember the section 28, 29, 30, 31 ऐसा कुछ था क्या? Let's go for the 9th point. Government department supplying water for the irrigation to the agriculture after the levying charges for water supplied can be considered as the enterprise here. Okay, so hope so this point is easy guys. The chairman of the insurance company regulatory development authority shall hold office for a term of how much year? 5 years. Let's go for question now guys. Section B, Moon Limited, Moon Electronicals Limited is a company in which Supriya Power Supplies the suppliers limited is holding 60% of its paid up share capital. One of the shareholder of S made a charitable trust and donated his 10% of share in S and 50 crore to the trust. He appointed M as a trustee. All the assets of the trust are held in name of Mr. Ken. A subsidiary holds share in its holding way in its way. So first of all we have to find out ki, whether the subsidiary can hold the share, and last line let me highlight, all the assets of the trust are held in name. This is in form of trust. ठीक है, and the second question is, can a subsidiary hold the share of the holding company in this way? First of all, subsidiary cannot hold the shares of holding company. Okay, but in some cases they can go for it. ठीक है, and first of all if that is in the trust, that is going to be one among that point exception. ठीक है, so let me read the exception here. where the subsidiary holds such share as a legal representation or deceased member of the holding company is one of the exception here. वो वाला कोई exception नहीं है. With the subsidiary holding company holds such share as a trustee. Yes, in the question there was a trustee. So here the company can go for it. Number third, let me read it also. So where the subsidiary company is a shareholder, even if it became shareholding company, subsidiary company of the holding company, but in this case it will not have a right to vote a meeting of holding company. So among these three, there was a point where the subsidiary company is a trustee. Okay, so yes, they can go for it. Let's go for the another question, which is of the B. 2 का B part. The promoter of KSR Private Limited, a startup registered company incorporated on 20th June 2022, is willing to accept deposit from the member. Okay, हाँ जी, the shareholder of Mr. K, Mr. S and Mr. R as on 31st March 2023 is under Mr. K, director of the company, holding 4,000 share of rupees 100 per share, Mr. S, friend of Mr. K, and Mr. R holding 3,000 share of 100 per share. The company is not having investment in any subsidiary company and associate company. The borrowing from the financial institution on 31st March 2023 is 10 crore. On the basis of this information, please advise whether the company can accept deposit or not. So let me read it, guys. Okay? So whether they can go for it or not, or if not, there would be some exception or not. Okay, as per company acceptance of deposit rule, any amount received from the person who at time of receipt of amount was a director of the company or a relative of a director of a private company is exempted under the deposit rule. Okay, so there was an exemption of this point. Okay, however, in this case, the director of the company or a relative of the director of the director of a private company, as a case may be, from with the monies received furnished to the company at the time of giving money, declaring in the written to the effect that the amount is not being given out of the fund acquired by him by borrowing or accepting loan or deposit from the other, and the company shall disclose the detail of money so accepted in the board report. Okay, so hence the company can accept the deposit as he is a director of the company with no limit on the amount of deposit. So further need to give the declaration on such thing. ठीक है, इतनी बात भी अपने को बहुत अच्छे से समझ में आ गई. Let's go for the other point. Let's go for the section, the C question of question 2. Comment with a reference to the provision of the Companies Act 2013 in respect of the following. Mr. A is not qualified to be appointed as independent director, is appointed by a board of director of IJK Limited for independent director. So first thing, to be appointed as the independent director, you have to be independent. अच्छा, एक बार पहले दोबारा पढ़ लेते हैं. Mr. A is not qualified to be appointed as an independent director, is appointed by BOD of IJK Limited for independent director as alternative director. So do you remember, first of all, what is the section of alternative director? 161 subsection 2 है क्या? Okay, ठीक है. So there was one point saying about for the alternative, the independent director, alternative director, है ना? For independent director, the alternative director should be independent director, and in this case, the person was already not appointed as an independent director. So this person cannot be appointed here as independent director. इतनी बात समझ में आ गई? हाँ जी. Let's continue. Okay. On the request of bank providing financial assistance, the board of director ABC Limited decided to appoint its board Mr. P as a nominee director. So first of all, in case of appointing of the nominee director, let me tell you, the nominee director are the financial watchdogs of the, where they are going to see what is company doing, how the company is doing and all. Okay, whether they are following the regulations, guidelines which is made by financial institution and all. Okay, but that is only going to be happen if that is authorized by article, okay, or that is specified already. Okay, otherwise it is not going to be taken. मतलब nominee director cannot be appointed. Okay, so here let me continue. Article of association of a company do not confer upon the board of directors any such power. So surely they cannot go for. So there are two parts. ठीक है. Number first, वो independent director, no, he cannot be appointed under section 161 subsection 2, and this is about nominee 161 subsection 3. So again, they both cannot be appointed. Okay, let's go for the D point. The audit committee of a listed company constituted under section 177 of the Companies Act. याद है क्या 177 रूल 6 था क्या भैया, या फिर रूल 7 था? Remember guys, rule 6 था क्या? Submitted its report containing the recommendation, it's in the report of certain matter to the board. Okay, the board however did not accept the recommendation in the light of suitable advice. Okay, so here the audit committee, and there are further question whether the board is empowered not to accept the recommendation of audit committee. So what alternative courses of action would be board resort to? Okay, so whatever the audit committee have given recommendation to the board is not compulsion liable to be taken that. Okay, if a board do not accept the recommendation which is given by audit committee under section 177, you have to mention the rule also. Okay, in that case the board definitely they are not bound to accept the recommendation, but with that they have to specify why they are not accepting the recommendation which is given by the audit committee. So this is the main point which is to be discussed here. Okay, so you have to mention that the board is not bound, but they have to mention in their report why they have not the following the recommendation, and if they have some other person, that should also be recommended. Okay, let's go for this question. Question number 3. While I was reading this question, I was little bit confused because I was thinking this question was related to financial creditor or the operational creditor, but once I read all the question, then I got to know about this. So yes, let's read it fully. BT was a restaurant located at a leased premises in Chennai. Okay, it had a great reputation, award-winning chef, tastefully designed interior. Much of its business come from executive lunches and dinners. Following the opening of NR, another excellent restaurant in the nearby vicinity, trading losses were incurred by BT and eventually it became the insolvent. Okay ji. Effort to either have the rent reduced or to sell the business were unsuccessful. Suppliers of food, beverage and the utilities were unpaid for supplies provided in previous 40 to 50 days amounting to amount rupees 80,000. There were rental arrears of 1 month amounted to 40,000 toward the landlord. Mr. David, the landlord, had received advance rent for 3 months. Lease deed provided for 1 month rent as a security and 1 month as an advance. So BT also had a secured creditor, IOB. The bank indicated that it did not wish to appoint receiver file for the insolvency as account were regularly maintained. BT was managed by Mr. Kannan as a sole proprietor. He employed a staff of 10 people including a chef, assistant chef, 6 waiters and 2 housekeeping staffs. The salary due to these employees were paid in half since the past 3 months. In the light of the above, whether BT can apply for the fresh start process or not, give answer the citing reason. So guys, first of all you have to identify which they are talking about, ठीक है, because this is related to insolvency and bankruptcy code, ये अपने को समझ में आ गया, but they are asking for कि whether they can go for the fresh this or not application or not, ठीक है, and this question was related to DRT, and earlier when I was reading the question I was thinking this is related to financial creditor or the operational creditor, but no, this is not related to that. So here let me read the answer. No, BT is ineligible for applying the fresh start process. As per section, the fresh start process for the individual under which will eligible for a debt waiver of up to rupees 35,000 Indian rupees. The individual will eligible for the waiver subject to the certain limited, where under section 18 Insolvency and Bankruptcy Code provide the debtor who is unable to pay his debt and fulfill the condition mentioned in section 2 of 80 shall entitle to make application to DRT for a fresh start process for discharge is qualifying asset, and the co-define the qualifying debt. It meant about due, which include the interest or any other sum due, respective amount owned under any contract by the debtor for the liquidator, some either immediately or certain future time, but do not include any excluded debt or debt to be extended insecure, or any debt which has been incurred 3 months prior to the date of application of the fresh start. So yes, this BT is going to be ineligible. Let's go for the other question, guys. So yes, that was a little bit tricky. Okay, so let's go for third ka B part. RS has granted an interest free loan to XY private limited with a condition to repay the loan within 3 years. Okay ji, XY private limited default to repay the loan. RS file a petition under section 9 of insolvency and bankruptcy code. 9 कौन सा था? ऑपरेशनल क्रेडिटर का था क्या? हाँ जी. To initiate the CIRP against the XY private limited after complying the required formalities, the executing authority dismissed the petition on the ground that it is an interest free loan and the applicant is not a financial creditor. So here, you know what, let me read the first 2 lines again, because the A have rejected the petition saying that this is interest free loan and the applicant is not financial creditor. Do you remember whether the person was financial creditor, operational creditor, or the corporate? They can go for the application, they have to file, they can go and file the application to AO. Remember the dates and all, ठीक है? हाँ जी. So RS has, I'm just reading the 2 lines more, guys, ठीक है? RS has granted an interest free loan to XY private limited with a condition to repay the loan within 3 years, ठीक है? RY private limited default, so here this is not the operational creditor here. The question is just confusing us, ठीक है? By quoting the section number, this person is going to be financial creditor, and the AO who have dismissed the petition that saying he is not a financial creditor, he is wrong here, ठीक है? So this is done to, you know, थोड़ा सा घुमाने के लिए अपने को दिया गया है ये क्वेश्चन. ओके, सो द रिजेक्शन ऑफ द एप्लीकेशन, लास्ट का लाइन में बताती हूँ, बिकॉज the person is going to be the financial creditor, even though the person is not going to be financial creditor, operational creditor can also go for the application to file, they can also file the application to AA. So the rejection of the application on this ground is not valid. Okay, let's go for the third ka C. The issued and the paid up share capital of the STD limited is 5 crore, consists of 5 lakh equity of 100 each. The said company had 500 member. Petition was submitted before the tribunal, signed by 80 members holding the 10,000 equity of the company, and for what purpose? The against the operation and misstatement by the majority shareholder. Examine the provision of the company, decide whether the said petition is maintainable, and maintainable of the above if the subsequently 40 members were signed withdrawn the consent. Remember 241, 242, 244 से ही रिलेटेड है, सेम वही वाले क्वेश्चन है, ठीक है? एंड सेम विड्रॉल वाला राजा मंत्री इलेक्ट्रिक सप्लाई वर्सेस नागेश्वर राव, ठीक है? सो वेदर इट्स गोइंग टू बी विड्रॉल, द मेंबर्स आर गोइंग टू विड्रॉ the application, it's not going to be valid, ठीक है? Once the process is initiated, it's going to be go on, ठीक है? And what were the criteria under 244? 100 member, 1/10 of total number of member, or one or more member who is holding more than 1/10 of issued share capital. Remember? हाँ जी. So it's easy, guys. Same वही चीज़ पूछी गई and we know this. Okay. Let's go for the other part, guys, which is of question 4th. नहीं, question D. Third का D. Mr. R was appointed as a full-time director and heading the marketing department in SMP Limited. As a cost-saving measure, he was removed. He was removed by the company. Do you remember? अगर ये person, the managing director, full-time director, or a manager was going to be removed forcefully by the company, under section compensation दिया जाएगा कि नहीं? Section 202. Remember? हाँ जी. So Mr. R demanded a compensation of a loss of a office. And explain the relevant provision of the company, whether he is entitled to commission. Yes, he is entitled for the commission. कितना ले सकता है, कब से ले सकता है? Just before the cessation of that time period, 3 years before, or the time period whichever is lower, which was he was there for, ठीक है? And there was a case also, I don't remember the name properly, which is related to liver Bell versus ब्रो लिवर समथिंग ऐसा ही कुछ था केस, मुझे याद नहीं आ रहा नाम, बट दैट वॉज द कंपनसेशन वॉज गिवन इन दैट केस, ठीक है, विच वॉज रिलेटेड टू कंपनसेशन for loss of the office. But later on it was disclosed that the director, managing director or the manager or the full-time director was actually liable for that let's say ki loss for the company. And you know what, ki compensation was already given to that person, that key manager person. Whether that compensation can be taken again once the compensation was given, nahi. Once the compensation was given to any of the key manager person, it cannot be taken back. This was one of the case also, ठीक है. I don't remember the case, just एक बार गूगल कर लेना आप, या फिर केस स्टडी में गिवन है तो एक बार वो देख लीजिएगा अंडर सेक्शन 202, ठीक है. सो हेयर ही कैन टेक द कंपनसेशन अंडर दिस सेक्शन, ठीक है. एंड व्हाट आर द प्रोसेस, अपने को पता है, एवरेज रेम्यूनरेशन अर्न बाय हिम ड्यूरिंग द पीरियड ऑफ 3 years preceding the date and he or on which he ceased to be hold such office or where he held the office for less than 3 years, ठीक है. It's going to be taken. Okay, let's go for the another question number 4th A. PQR Limited is a wholly owned subsidiary company of the STU Limited. The company wants to make application merger of holding in subsidiary. हो सकता है क्या merger of holding in subsidiary? बिल्कुल हो सकता है, 232 के अंडर हो सकता है. Okay. The company secretary of the STU Limited is opinion that the company cannot apply for the merger and the company shall apply for a merger as per 233 as fast track merger. Okay, first of all the company can go for this, ठीक है, because one company is holding and the another is subsidiary. Do you remember there was another also under section 233 where that was saying about 232 or 233 it was, ठीक है, which was saying about that ki small company, one should be merger, one should be holding, another should be subsidiary, wholly owned subsidiary, a third which is criteria which is specified, ठीक है. So here the company secretary is wrong, and with that the company secretary is saying that they can only apply for the fast track merger. This is actually not compulsion merger, the company can go for this, this is option given to the company. So here again company secretary is not right, it's his valid, his opinion, it's not valid as per the law. Let's go for the question number B of 4th. Before imposing penalty, the executing authority issue a showcase notice to the company and its officer on 15 July 2023 to represent before the educating authority. Okay, the notice was served on him on 31st July. State the time period within the company and its officer were called upon the presumed before the educating authority. Let me see, this is actually not for us as per 2022 syllabus. There was this question was in 2016 syllabus, ठीक है, तो इसको नहीं देखने का. Let's go for C question 4th का. FRC Limited is a foreign company having its place of business in Chennai, okay, and in Bangalore, okay. It has amended its MOA on 1st of June and closed the office branch situated in the Chennai, referring to the provision of the companies. Now we have to advise the company on the following matter: the compliance procedure as regard to amendment of the memorandum of association, number first. Second, compliance procedure as regard to closure of Chennai office and discontinue submission of the document to the registrar office. Number first was of amendment. If there is any amendment, then within 30 days of such alteration, the information, the document is to be delivered to the registrar for registration and return containing particular of the alteration in a prescribed form, ठीक है. And second case, in case of closure of the Chennai office, the company have not submitted the submission of documents, documentation and all to the registrar, where the company is wrong, and that is to be submitted even though the company go for discontinuation of or the closure of the company, ठीक है. Even though that is going to be happen, they have to submit the documentation to the registrar. Okay, let's go for the next point. ये वाला question भी नहीं है अपने को, ठीक है. D वाला question of 4th part. Let's go for the other part guys, which is 5th point, 5th का A. So I have already discussed this point while I was taking the fast track revision of this point. Okay, let me read the question first. SEBI received complaint from some investor alleging that the KLM Limited and some brokers are indulging in price manipulation in share of the KLM Limited. Explain the power that can be exercised by the SEBI under the Security and Exchange Board of India 1992 in case the allegations are found to be correct. Number 4, they can suspend them, right, and they can restrain that person ki you cannot enter the security exchange market and all. Okay, with that there is some of the penalty under section 15H जो आप मेरे नोट्स में आपको आराम से मिल जाएंगे. And that penalty is that of a person if is indulged in fraudulent and unfair trade practices which is related to security. He shall be liable to penalty which is not less than 5 lakh rupees and may be extended up to 25 lakh crore. ठीक है, okay. So number 4 up to starting from the 5 lakh and it's going up to 25 crore. ठीक है, or the thrice of the amount which the person gained the profit out of the parties practices and all, whichever is higher. So this is all about this part which we have to keep in your mind. Restrain कर सकते हैं, suspend कर सकते हैं, ठीक है. With that the penalties you have to write. बट आपको ये सब तभी पता होगा जब आपको थोड़ा सा पता होगा, है ना. तो आप देख सकते हो आराम से, मेरे नोट्स में आराम से दिए हुए हैं. लेट्स गो फॉर द अदर पार्ट. द बोर्ड ऑफ 5th का बी, द बोर्ड ऑफ डायरेक्टर ऑफ द बिग लिमिटेड propose to transfer more of the 10% of the profit of the company to reserve of the current year. Advise the board of director can do this or not. Yes, the company can go for it as per section 1, 2, 3 subsection 1 of the company. The company can go for it. Okay, so there is no any problem with that, but they have to discuss with the board of directors and all. That's it. There is no compliance that they cannot go for it. Let's go for C part. In what way does the company restrict the non-cash transaction involving director of the public limited company? Yes, there are some transactions which is restricted on non-cash transaction involving with the director under section 192. I am going to read it because we have not covered it. Okay? So no company shall enter into any such agreement by which a director of a company of its holding subsidiary or associate or a person connected with him acquire or is acquiring asset for the consideration other than cash from the company. The company acquires or is to acquire the asset for consideration other than cash from such director or such a person so connected unless prior approval of such agreement is accorded by the resolution of the company in the general meeting. And if the directors or connected person is director of his shareholder, an approval shall be required by passing a resolution in the general meeting. Second point is the notice for the approval of resolution by the company or a holding company in a general meeting shall include the particular of the arrangement along with the value of asset involving such arrangement which is duly calculated by the registered officer. इतनी भी बात समझ में आ गई. हाँ जी, ओके. एनी अरेंजमेंट entered into the company or its holding company in contravention of the provision of this section shall be voidable at the instance of the company unless the restitution of any money or other consideration which is subject matter of the arrangement is no longer possible and the company has been indemnified by a person or a loss or a damage cost to it, or second, any right are acquired bona fide or value without notice of contravention of the provision of this section by any other person. ठीक है. So this I have not actually covered earlier, तो इस वजह से मैंने इसको थोड़ा reading किया and it's important also. Let's go for the other point guys, which is question number 5th का D. Upon inquiry made by Competition Commission of India, guys, the same thing which we already discussed. Okay, Competition Commission say related, which is related to dominant position. Okay, I'm just going to read because we know the answer. So question C is 5th ka D. Upon an inquiry made by the Competition Commission of India, it was found that Heavy Limited is enjoying the dominant position in the market and there is every possibility that the company may abuse its dominant position. In order to overcome such position and situation, the Competition Commission of India wants to order for the division of the heavy limited. So whether they can go for it or not, definitely they can go for it, because it's one of the power of the Competition Commission, which we already read, okay, under section 28, and we know this. Let's go for the other point, guys. Referring to the provision of the Foreign Exchange Management Act 1999, examine whether VK, an exporter, is bound to make declaration of gift of jewellery valued ₹20,000 exported from India to USA, whether this person can go for it or not. So he is also required to repatriate the foreign exchange due to India in a time which is specified by the whatever authority it is, okay. But there is some amount which is prescribed. As this amount, the question was given 20,000, okay, but in actual the person can go for any of the object, jewellery, gift and all, okay, which is up to 5 lakh. So this amount, which 20,000, is less than that. So definitely this gift does not need any declaration to be furnished by the exporter to the specified authority. So he can go for it, okay. Okay, let's go for the 6 ka B part. Mr. Karuna has been employed in France for 3 years. He was involved in a conduct which constituted offence in France. The conduct would have been considered an offence in India as well as it had been committed in India. The proceed involved in the offence was 60 lakh. Mr. Karuna attempted to remit 50 lakh out of 60 lakh to India but not successful, ठीक है. This question is related to कौन सा वाला part, money laundering वाला part, ठीक है. part कौन सा था, C वाला part, ठीक है, trans border crime. But here the person was unsuccessful. मैंने इसी केस को डिस्कस किया था guys. Well, I was giving you the reference of question, ठीक है. The government of India held the offence as an offence of cross border. Implication as per section 2RA of the Prevention of Money Laundering Act 2000. State whether the contention of the government of the India is correct. Now, what is going to be the answer? As we all know, if the question have the crime have not committed, whether the government can take initiative? No, the government cannot take the initiative. Here the government is wrong, okay. So if the person have indulged in such activity and the crime is not involved, so the any authority cannot take the action against that person, okay. Let's go for so here the government is wrong, okay, not tenable. The action taken by the government, it's not correct, okay. Let's go for the question 6 ka C, which we all know, principle of causa proxima, okay. Whatever the cause of accident, whatever the cause is going to be, the appropriate cause should be taken. If there are so many other causes, okay, so for that appropriate cause should be taken, okay, which is nearer to that thing, okay, which we already discussed. Let's go for the D part of the questions 6. Enumerate the manner and the effect of takeover of management under the Sarfasi Act. Do you know this question? Section number 15 का था क्या ये? हाँ जी. Where do you remember the director can be appointed, right? Administrative can be appointed by whom? By the secured creditors, remember, Hannah? And with that, the directors and other superintendent is going to vacate their office. If there is any contract between the directors and the management is going to be terminated. If any other decision cannot be taken, like any special resolution, or like they want to wind up the company, that could not be possible, right? Or any of the regulation would not be taken place. It should be approved by whom? By the person who was appointed by the secured creditor, by the directors or by the administrator, ठीक है. So they cannot go for it, ठीक है. हाँ जी. So we have already discussed this part. Section 15 is about that. Let's go for the 7th question. The typical organization structure of the PSU make it difficult for the implementation of the corporate governance practices as applicable to other publicly listed private enterprise. So is in the given context, list the difficulties encountered in the governance. So we have to write it down guys, ठीक है, कि the chief executive and the management directors are likely to bureaucrat and not necessarily professional with the required expertise and all, ठीक है. So we have to highlight the main problem which is faced by them basically, ठीक है, competition से related हो, professional से related हो, ethics से related हो, ये सारी चीज़ें. Okay, let's go for the other point guys. Discuss the corporate issues that crop up the family owned and business. Do you remember? Which is related to ownership and management, family conflict, है ना, the employment which is to be chosen among them, है ना, employees is to be taken among them. Okay, ये सारे के problems इसमें था which we already have seen in the scanner. Okay, let's go for the C part of this question number. What should company evaluate a CSR project? Okay, let's read it easily. We know these things. The following steps should be taken for the proper evaluation of CSR project, and in which would be taken funded by the company, which is scrutiny of the document of the implementation, the inspection or the satisfaction with document, need analysis nature of the beneficiary, the feasible of the project, the track record of the implementation agency, the financial capital revenue expenses, the parallel financing by the government, and the joint financing. Okay, these are the things, and with that we have to write what is the meaning of corporate, what is the social meaning, what is the responsibility meaning. They've breaken the term corporate social responsibility, so they have write the meaning of each and every term here, ठीक है. So आप अपने हिसाब से लिख सकते हो, ऐसा कुछ नहीं है कि सिर्फ इसमें जो लिखा है वही लिखना होगा आपको, ठीक है. Just have to remember the points, the heading and the key points, and then you just frame the answers by your own, ठीक है. Let's go for the other point, which is write a short note on any four. So first point is corporate insolvency resolution process, we know, but here we are going to write the other part, other chapters which is divided in there. As I told you, there was a fast track corporate insolvency resolution process one among them, okay? That is option given to the company, that is not a compulsion, right, where the company is bound to go for that, okay? That is given, the option given to them. So number first is corporate insolvency resolution process, which we know. Second is going to be liquidation process. Third is going to be fast track. Fourth is going to be voluntary liquidation. Fifth, educating authority for the corporate person, and sixth is going to be offenses and the penalties. Okay, so these are the process which people are also, and another process is going to be there. Okay, let's go for the derivative under section security act. ये आप छोड़ सकते हो because अब अपने ये है नहीं security वैसे, so you can leave this part. Provision for the investigation of the combination, okay, and which we know 30 days के अंदर for the procedure for investigation के लिए अपील कर सकते हैं, remember, हाँ जी. So this you have to write. Let's go for the government to business, which is G2B initiative. So here E procedure project for the purchase, government purchase is mentioned, and let me read it, है ना, क्योंकि it's a different question, we have not seen such questions so far in the previous attempt. So let's go for it. G2B initiate encompass all the activities of the government which impinge upon business organization. These include the registration under the different statutes, license under the different laws, and the exchange of information between the government and the business, as the name is specifying about the government to business. So yes, we know this. The objective of bringing this activity under e-governance is to provide a congenial legal enterprise environment to the business, EPD various process, and the provide relevant information to the business. Okay, some of the information important initiative are the further below. E-procurement project for the government purchase. It is an initiative for the procurement of material through the e-tender process by avoiding human interference. Okay. Supply and buy and track during the pre-bidding and the post-bidding stages. It is initiating to establish transparency in procurement process, shortening of procurement cycle, and availing of competitive price, enhancing the confidence of the supplier, and establishing feasible economic bidding process of the supplier. MCA 21, the project aim at providing easy, securing online access to all the registry related services, provided by the Union Ministry of the Corporate Affairs to the corporate and other stakeholder at any time and in any manner which is going to be suitable for them. ठीक है. So this is what is related to a business which is related to government. ठीक है. Definitely where the government is taking place. ठीक है, interacting, but the buyer and seller is they cannot interact. There is a transparency but they cannot see each other. ठीक है. Okay. Let's go for the report of committee on the corporate governance, which is basically related to the protection of the various stakeholder and which is related to insider trading. ठीक है. So this we know. ठीक है, where we have to write about the stakeholders right, shareholders right. ठीक है, and some of the disclosure transparency which is to be maintained by the company. With that, the protection which is related to insider trading. Okay, so we have completed so far 3 question papers, guys. So I'm going for 5-minute break. I'll back in 5-minute break. I'm not going to close this, I'm going to pause this. Okay, so I'll be back in 5 minutes. Okay, give me 5 minutes. Okay, I'm going to turn off my camera and voice. Okay, chalo, bye, we'll meet in 5 minutes. Okay guys. So yes people, we are going to resume our class. Okay, so yes, we are having the 2023 December question paper and as per syllabus 2022. Okay, so let me see whether I am visible and all. एक बार रुकना. Okay, yes, let's go for it. Okay, so I'm going for the question which is about the MCQ in term of section 1, 2, 3, 4. The amount of the dividend including the interim dividend shall be deposited in the scheduled bank in separate account within how much days? So as per this question, the answer is going to be 5, but actually the answer is going to be 7 so far as my knowledge. So here the in the scheduled bank it should be deposited within the 7 days from the date of declaration of such dividend. Okay. Second, where any company change the place of register office from the jurisdiction of one registrar to the jurisdiction to the another registrar within the same state, the such change is to be confirmed by the regional division director here, okay, on application made by the company. So the answer is going to be C. Third, consolidated financial statement shall be sent is not less than 21 days before the date of meeting, may be sent less than 21 days before if the shareholder with the right of voting is going to be 95%, then only it's going to be applicable. Okay. Fourth, the forcible taking of the property by the company's law official, enforcement official from a person who is suspended or violation of the law is known as seizure. Okay, so the answer is going to be fourth here, D. Fifth point says in which of the case minimum contribution should not be less than 20% of the post issue capital, which is going to be initial public offer के case में should not be less than the 20% of the post issue capital. Let's go for the sixth question. The MCQ, banking company incorporated in India are obligated to the transfer to the reserve fund of some equivalent which is not less than 20% of the profit each year unless the amount is such fund together with the amount in share premium account it's not more than or equal to its paid up share capital. Okay. Under which principle of the insurance or a promise whereby the assured undertaken that some particular thing shall or shall not be done, or that some condition shall be fulfilled or affirm or negative the existence of a particular state, and that is what the warranty states. Okay, then let's go for the 8th point. Bank pay dividend after taking special approval from whom? By the Reserve Bank of India, then only they can go for by paying the dividend. Let's go for the 9th. It is a public private partnership project to the project provide a single window self-sustainable e-governance solution with regard to handling of grievance which is related to land record maintenance. ठीक है, और इससे related question भी आया है. And providing a mixture of essential services, and this project is known as Lokwani project in UP. Okay, so the quality of something which enable 10th point, 10th MCQ, want to understand the truth easily in which the consent of the corporate governance implies an accurate, adequate and timely disclosure of the relevant information about the operating result. The principle of the corporate governance is known as here, it's going to be transparency. The second, the B is going to be answer here. Let's go for the 11th part, abuse of dominant impetus for the fair competition between the firm, explaining consumer and make it difficult for other players to compete with the dominant undertaking on the merit. It is not going to include the fixation agreement to fix the prices. We remember the point, remember Hanji. So let's go for the question which is the paragraph, and from this paragraph it's going to be 4 questions from 12 to 15 is going to be consist. Okay, let's read it. PQR Limited has its board of director ABCD. In addition, the company has Mr. E as managing director. The company also has a full-time company secretary, Mr. F on its roll, the financial creditor of the company, balance sheet and statement of P&L and board reporting for the year were authenticated by two directors B and C under their signature, referring to the provision of the Companies Act 2013. Examine the validity of the authentication of the balance sheet and the statement of P&L and board of report. So in case of one person company, it's to be one person company by, it's going to be one director only in this case, so it's going to be third point. In case in other case, at least by the chief financial officer of the company, wherever he is appointed, it's going to be this point. So if there is no chairperson of the board, the financial statement should be signed by whom? By the managing director. So in this case, E is the managing director. So the answer is going to be B. And let's go for 15. The board director should have signed by any director out of the 4. Okay. Okay. So let's go for some of the point which is saying about the, is there any provision for the prohibition of acceptance of deposit from public existing in the company? Do you know there is some any of the this point which is covering here? Let me go for this point, guys. Let me check whether I am having this point or not first, है ना? एक second, है ना? So yes. So in this case, let me read it one by one. No company shall invite, accept or renew the deposit from public except in manner of providing under chapter 5th. Yes, we know this. And provided nothing in subsection shall apply to banking company and a non-banking financial company and such other company as the central government may be specified. So a company may, with the mandate of resolution in general meeting and subject to rules, may be prescribed, accept deposit from its member on such terms and condition, otherwise they cannot go for it, and they have to file, once this part is done, they have to file a copy of circular along with such statement to the registrar within 30 days before date of issue of such circular, and deposition on or before 30 days of each and every year is to be done, which is not less than 20% of amount of deposit maturing during the following financial year, which is kept in the scheduled bank in a separate bank account. Okay, so this we have to follow. Okay, so let's go for the other question, guys, which is related to P, section B ka question 2B. All related party transaction shall require approval of the audit committee, and the audit committee may make omnibus approval, okay, for related party transaction proposed to be entered into the company subject to certain condition here. So elucidate the condition to omnibus approval of the related party transaction. First of all, we have to understand what is this omnibus approval. This means pre-approval granted by the audit committee for the repetitive RBT or the RPTs are not foreseeable in full details for time of approval. So basically we can say which is in continuous basis, okay, or like repetitive basis. Okay, so in this case approval from board audit committee is to be taken. Okay, so some point I am going to discuss here, I am not going in depth again. The audit committee shall, after obtaining approval from BOD, specify the criteria of making the omnibus approval, which shall include the name of maximum value of transaction, maximum value per transaction allowed, and the review such interval such audit committee shall deem to fit, and repetition of the transaction, the nature which was related to past and future it's going to be, and with that it contains the name of related party, the nature, the duration, tentative base price and all. तो ये सारे चीज़ें इसमें mention होना चाहिए, and that value should not exceed 1 crore per transaction and all. ठीक है, so these things to be written, it is to be done by audit committee, it's to be discussed by audit committee and should be approved then only, otherwise it won't be possible for that. Okay, let's go for the another question which is related to, we know this section 180 of the Companies Act provides a certain restriction on the power of board. Remember, there were 4 points related to this. 180 subsection 1 clause A, 180 subsection 1 clause B, okay, then clause C, then clause D. Okay, so what were they? which was sale to, they cannot, the BOD cannot go for sale, lease, dispose of substantial undertaking, remember, hanji. And then they cannot go for invest from the amount which is received from the merger, compensation of merger, right. Third, borrow money, they cannot exceed the borrowed money and the amount to be borrowed of excess of paid up share capital, free reserve and security premium. If it is going to exceed, in that case what is going to be happen, special resolution is to be taken. And to grant remit any director, okay, on repayment of dues. This was certain restriction on power of board of director. Let's go for the 3B. Briefly narrate the provision of 135 relating the minimum contribution. So we know this part, minimum contribution 2% होगा of average of 3 financial year, ठीक है. So contribution related to what CSR is going to be, and what if the amount of 2%, maximum कितना होगा 5%, okay, ये भी अपने को पता है. So what if the amount contributed is not specified, it's not contributed, then it should be mentioned in the board and with the reason, and the reason why it's not allocated, that the amount is not attributed, okay. And the directors, the committee's director and the chairperson should sign it, okay, and discuss it why it wasn't actually done, okay. So now let's go for the board of director. Question number 4, the BOD of PQR Limited met thrice in a year 2022 and fourth meeting through court but couldn't held for the want of the quorum. Examine with reference to the relevant provision of the Companies Act whether any provision of the Act has been contravention. So this is related to the meeting, okay, and meeting should be held at least 4 times in the year, right, and the gap should not be more than 120 days. Do you remember? हाँ जी, as per section 173 था क्या? हाँ जी, याद करो. Okay, so this is to be done, guys. So there are some provision that the fourth meeting was not held, ठीक है, and what if due to some हो गया भाई, कोई रीज़न की वजह से हो गया, ठीक है. सो इफ़ इट वॉजंट हेल्ड, सो व्हाट शुड बी डन, द अर्जेंट मीटिंग शुड बी हेल्ड विद इन नेक्स्ट वीक within the same place where it was going to be held, and say it at the same time, okay. So what if that was the date which was decided by the company, it was a national holiday, in that case the meeting should be held the next day, okay. So let's go for the fourth B, where the KFC Limited was registered as public company. There are 230 members in the company as noted. So the director and the relatives is equal to 15, employees equal to 15, ex-employees is equal to 10, and 5 couple holding other shares, name of husband is equal to, another is going to be 145. So basically in private company they cannot be more than 200. So in this case it is 230, but all over it's going to be 200. So we have to keep this point in our mind. This is all about this section, okay. So we have to tell whether the company is in the limit or not in the limit, okay. Let's go for the question 5th A. How far the act of the director will be invalid if the appointment is not valid? We know the answer. The act of, as per section 176 which we already discussed, the act of director is going to be validity only if, and what the managing director का भी it's not going to be non validated in some cases, ठीक है, terminated हो, disqualified हो, ये सारी चीज़ें थे. So we know this as per 176. Let's go for the other question, which is in scheme of responsibility of multinational company listed in India, the company wanted a minority shareholder to get out of the company by selling their shares back to the promoter at a price determined by the promoters. Do you remember there was the minority वाला shares, remember compromise arrangement में था क्या? हाँ, so there was a section related to them, right? They can appeal to tribunal, right? Okay, and here the value was decided by the registrar valuer, right? Here in the question they have given that the price is determined by the promoter, which is wrong, okay. Hanji, the minority shareholder were not given a choice whether they want to tender their share or not. So this is again wrong. They have a right to do that. They have tender, they can go for this choice, okay, कि they want to sell or not. But for this 90% of share should be taken by the majority, remember, तभी वो ले सकते थे, okay. In the meeting, there were 6 non-promoter shareholders who voted against the scheme, but the chairman declared that the motion was carried out with an overwhelming majority of more than 90% of shareholders. First of all, the question is wrong because the offer can be rejected. The offer is only going to be accepted by the value which is determined by the register value. So here, the promoter cannot do this part. Okay. So let's go for the next question, which is related to prepare a statement of feature of the corporate governance. Again, this is very easy and simple question. We have to determine tell the feature which is going to be transparency. Okay, it is a tool which is going to give a proper transparency for the enterprise. Value of the enterprise is going to be created. With that, the ethical values are followed there, okay, which also increase the value of enterprise for sure. The customer's loyalty is going to be gained by the enterprise. Accountability, innovation, professionalism is maintained by them. Stakeholder recognition, ये सारी चीज़ें होती हैं, ठीक है. Let's go for the other. The business intelligence has some process of work. Question 6b. Ejaculate the process of the work. So let's go for this. The process work of the business work, वही चीज़ें स्टोरेज होती है, एनालिस होता है, डाटा प्रिपरेशन होता है, स्मूथली वर्क होता है. एंड दिस इज सिंपल क्वेश्चन विच इज आस्क्ड. ठीक है, लेट्स गो फॉर द नेक्स्ट पार्ट. क्वेश्चन 7th का ए. इशूअर कैन नॉट मेक अ पब्लिक इशू. डू यू रिमेंबर? हाँ जी. और अ राइट इशू ऑफ इक्विटी शेयर और कन्वर्टेबल. अब याद आ गया, सीधी सा पार्ट क्वेश्चन है भैया. ठीक है जी. सिक्योरिटीज अंडर सर्टेन कंडीशन, एक्सप्लेन द कंडीशन ऑफ पब्लिक इशू और अ राइट इशू ऑफ इक्विटी शेयर and convertible, this one. So what was the issue? Remember, if a issuer or a promoter or promoter group, the director, selling shareholder are departed by accessing the capital market, remember? हाँ जी. So वही वाला 75% should be of fund should be arranged, 25 from the outside, remember? Okay. And with that minimum time period is going to be 3, maximum is going to be 10, 90 minimum subscription is going to 90% of the issue size. Dematerialization होना चाहिए. Okay, so these are the point which we already discussed and it's easy. सीधी सा part question आया. Go for the question number 7 का भी. penalty offenses to furnishing the information under competition act. This you have to read guys, ठीक है, because कुछ चीज़ों में we cannot do anything. We have to go for rectification in some of the cases. Okay. Let's go for the 8th का A, which is discuss the permitted investment by a person outside India. ये भी अपन बहुत अच्छे से पढ़ चुके हैं while doing the revision. Which is subscribe, purchase, sale of the capital instrument of Indian companies permitted as per the direction. Purchase of sale of capital instrument of listed company, right? Purchase of sale of other than, ये सारे चीज़ें अपन ऑलरेडी बहुत अच्छी तरीके से पढ़ चुके हैं. सो दीज आर द सेम थिंग दे आर सेइंग. ठीक है, सो देयर इज नो वरी, वी नो दिस क्वेश्चन अगेन. लेट्स गो फॉर द एसेट रिकंस्ट्रक्शन कंपनी में for purpose of asset reconstruction provide for one or more measure elucidate that measure to be taken for the asset reconstruction as per section. Do you remember the section 9 with the security enforcement, section 13? there were so many other. ये debt reconstruction वाला हो सकता है, proper management of a business हो सकता है, sale of liens होता है, rescheduling हो सकता है of payment, है ना, enforcement of securities के साथ साथ settlement of dues payable by the borrower, taking possession, सारी चीज़ें. So it's that easy. Actually पता है point क्या है कि आपको point थोड़ा सा याद रखना पड़ेगा. If you are able to recognize or remember those points, then you can easily frame the answers. ठीक है, so this is all about this part guys. This question paper is also done. Let's go for the last one guys. I'll be quick. ठीक है, I'm not going to take your more time, so let's be quick. Okay, it's going to be December 2019 attempt as per syllabus 2016, as उस वक्त यही था. Let's go for this. The company shall furnish to the register verification of its register office within how much time period? 30 time period from the date of its incorporation. Out of the following, which item can be excised by the board of director? That is cannot be excised. Definitely it's going to be sell or whole or substantially whole of undertaking of the company under section 180 subsection 1 clause 1. ठीक है, clause A. Let's go for the third MCQ. The board may fill any casual vacancy. Casual vacancy के नाम से मुझे याद आना चाहिए 161 subsection 4 कितना मंथ 3 मंथ है ना, हाँ जी. So this is what they are asking. मैंने पढ़ा भी नहीं है लेकिन क्वेश्चन पढ़ना है. ओके, सो लेट अस रीड इट. इन द ऑफिस ऑफ द डायरेक्टर विद इन 30 days, बट वेयर सच वेकेंसीज कॉज्ड बाय रेजिग्नेशन of the auditor, such appointment shall be approved by the company at the general meeting concerned within the 30 days of recommendation of the board. Okay, 30 नहीं 3 months. Okay, हाँ जी. So let's go for the fourth point. In case the controller and the audit general of the India does not appoint first auditor within the stipulated date, who will appoint such auditor within the next 30 days? In that case, board of directors is going to appoint. Fifth point, under the principle of corporate governance, it implies the responsibility of the chairperson, the chairman, the board of director and the chief executive for the use of company resource in the best interest of the company and its shareholder. That's what says about the accountability. Sixth question, any person agree by the order, ये अपन छोड़ सकते हैं because we have no NCLT now. आउट ऑफ सिलेबस है अपने लिए. विच ऑफ द फॉलोइंग इज नॉट द ऑब्जेक्टिव ऑफ प्रिवेंशन ऑफ मनी लॉन्ड्रिंग. वेदर टू प्रिवेंट द कंट्रोल ऑफ मनी लॉन्ड्रिंग नहीं. वेदर टू कंसोलिडेट एंड सीज द प्रॉपर्टी ऑब्टेन फ्रॉम द लॉन्ड्रिंग मनी नहीं. वेदर टू जनरेट प्रॉफिट फॉर अ individual or a group, yes, or to deal with any other issue connected with the money laundering. So third is going to be the answer, to generate profit for an individual and a group. Let's go for 8 point. Promise whereby the assured undertake that some particular things shall or shall not be done, on that some condition shall be fulfilled, or affirm or negatives the existence of particular state of the fact. The principle of the insurance is known as here warranty के बारे में बात कर रहे हैं जनाब. Which of the following is not benefit of CSR? अगेन यही क्वेश्चन अपन पढ़ चुके थे, है ना. MCQ यहाँ से सेम आया है ना. Which of the following is not the benefit of CSR program? Which is mutual trust. Okay, others are the same. Let's go for the last. An agreement or an arrangement in a writing for the transfer of the asset or a fund, goods or secure services from or the corporate debtor is known as what? A transaction. Okay, so hope so this point was clear to you. Let's go for question now guys. एक बार रुकना. Okay, and we know the answer by the way because this is related to I guess a dividend वाला part है क्या. Let's read it. The board of director XYZ Limited is its meeting declared a dividend. It's paid up equity share capital which was approved by the company's annual general meeting. In the meanwhile, the director at another meeting of board of directors by passing a resolution to divert the total dividend to be paid shareholder for the purchase of investment for the company. As a result, dividend was paid to shareholder after 45. ये वाला क्वेश्चन मैं सीधा करा चुकी हूँ क्या? हाँ जी मैं करा चुकी हूँ. So it should be declared within 30 days. Okay, within date of declaration of dividend. If it is not, then within 7 days it should be deposited to unpaid dividend account. Okay ji, haan ji. So this we have already discussed. Let's go for the 2B part which says about an understanding has been reached among the manufacturer of the cement. Competition Commission वाला है क्या क्वेश्चन? Competition Act 2002. हाँ जी, to control the price of cement, but the understanding is not in writing. Whether it's in writing, whether it's not in writing, that is going to be arrangement and that is going to be legal. So yes, whether the understanding can be considered agreement, yes it's going to be considered, it's going to be answer. Next, Soma Nidhi Limited proposed to reappoint Mr. X director who has completed the term 10 consecutive year as a director of a Nidhi. So state your view about the validity. First of all, if that person have completed the 10 consecutive year, in that case the 2 years should be passed from his cessation or vacation, okay, of his office. So this person cannot be reappointed until unless that 2 year is passed. Okay, let's go for the second ka C question. There are 4 again question. Which type of public enterprises entered under special act of parliament? Let's read this part guys, ठीक है. Actually this is again not in our वो वाला part I guess. So let me see first. Then I'll tell you which part of enterprise is established under the special act of parliament, which is statutory corporation. Okay, this we know basically. How can a foreign company access Indian security market for raising fund? That is through Indian depository receipt only. Again we know this term. Which type of listing provide arbitrage opportunity to invest? That is multiple listing. And then fourth, how many times extension of the period of corporate governance resolution process can be granted? So that shall not be granted more than once. It is only going to be granted for one time. ठीक है जी. Let's go for the question. On the ground of question number 3, on the ground of conviction for an offence dealing with the related party transaction 188, Mr. Bat was disqualified to hold the directorship. The board filled up the vacancies by appointing Mr. Samarth as a director, which was subsequently approved by the member in immediate next board meeting. Mr. Samarth expired on 15th after working for 40 days as a director. Now the board now wish to fill up the vacancies. So first of all, whether the board filled up the vacancies earlier? Yes. There was a casual vacancy under section 161 subsection 4. So here the board have already filled the vacancy earlier, and we know further once the board have actually filled the vacancy, they cannot appoint another person in term of casual vacancies. Remember under section 161 subsection 4. Okay, so advise board on the availability of this part. Appointment of Mr. Samanth in place of Mr. Bad and appointment of Mr. Bali in place of Mr. Samanth. So you have to decide. Okay, first of all, in this case Mr. Bat was disqualified by hold the directorship, so he is not going to be appointed as director in this case. Okay, so let's go for the 3 ka B part. Domain India Limited owns the sum of 2,80,000 to S, who assign his debt to his two of the creditor R 1,40,000 and Mr. M to extent of 1,40,000. Mr. M make a demand for his money for the company from the company giving a legal notice. Yes, we know. The company could not meet Mr. M demand or otherwise satisfy with him. Expiry of 4 weeks from the date of notice. Mr. M therefore moves to NCLT with application of initiation of insolvency resolution process. Decide whether application filed by M can be accepted by NCLT. Yes. Okay. Yes, with that demand notice, this person, the operational creditor, have to give, or the financial creditor, let's say, okay, have to give the other documents with that, okay, and other document which is mentioned by board of directors and all, and the name of insolvency resolution professional who is going to be appointed as insolvency resolution professional if any of the disciplinary proceeding is not against him. Okay, so yes, within a few days either that is going to be accept or reject, remember, so that is going to be the answer here. Now state matter the deal with the management discussion and analysis report as per SEBI guidelines, which we have already discussed. The report is to be sent, okay, as per SEBI guidelines. 4 reports थे, okay, quarterly basis, end basis, ये भी था, okay, which is to be done. Let's go for the 3 का C part, which is true false. Overseas citizen of India means a person resident outside India who is a citizen of India. No, it's false. As per SSI secretarial standard on meeting or board, quorum is not required to be present throughout the meeting. That is again wrong. Quorum is to be required to be present in the meeting, board of meeting. Locked in security is going to be third point. Of promoter shall not be eligible for pledge with the commercial bank, financial institution as collateral security. That is again false. Number 4th, the asset reconstruction company means a company registered with a reserve bank under 3 for the purpose of carrying on business of either asset reconstruction or securitization. This is again false. Okay, so let's go for the 4th question, guys. So hope you are understanding, because these we have already completed, so it's easy for us to understand now. Let's go for 4th point. The article of association of the listed company provide for the fixed payment of sitting fees for each meeting of director. Maximum of the 30,000. In view of increased responsibility of the independent director of the listed company, the company proposed to be increase the sitting fees to 45,000. So advice about the requirement under the Companies Act 2013. So first of all, we know the remuneration is not included, the sitting fees is not included in the remuneration of the director, okay, and the maximum meeting, the fees given for a director to attend the meeting is going to be 1 lakh. So here earlier it was 30,000 and it was increased up to 45,000. So it is allowed, okay, so it is allowed as per the provision, okay. So yes, let's go for 4B. Which is XYZ Limited was incorporated by furnishing false information. This is, we can leave because power of tribunal they have asked and we have know that chapter now, okay. Let's go for the 4th ka C. Briefly state the compliance requirement under Company Act 2013 regarding the risk management policies. This you have to look because abhi there was a question related to scanner also. तो आप एक बार ये चीज़ को देख लेना क्योंकि थोड़ा सा रट्टाफिकेशन करना होता है, ओके, उसमें मैं कुछ नहीं कर सकती. Let's go for the D part, which is fill up. Under IBC 2016, the resolution plan shall be approved by a committee of director by vote not less than 66% of the voting share. This we know, okay. So the answer is going to be 66. Reserve Bank of India may check the condition that the asset reconstruction company has not incurred any loss. Just a second. हाँ, बंद तो नहीं होना, मेरा फ़ोन का चार्ज ख़त्म होने वाला है. मैं जल्दी जल्दी बोल देती हूँ. Okay, so it should not be incurred any loss within 3 preceding financial year. And third says about the 25 section of Banking Regulation Act have to maintain the asset equivalent to 75% of demand and the note time liability. And fourth says about the according to section 14 of the Banking Regulation Act 1949, no banking company shall create any charge upon the unpaid capital. ठीक है, छोटी छोटी बातें जो कि अगर याद रहे तो बहुत बढ़िया, नहीं रहे तो again it's going to be difficult for us. Let's go for 5th question. One of the object clause of Memorandum Association Information Committee Limited conferred upon the company power to sell its undertaking. Do you remember the point whether they can go for it? No. And with the identical objective, company's article also referred upon the director power to sell or otherwise deal with the property of the company. At the extraordinary general meeting of a company, member pass an ordinary resolution for the sale of its asset on the certain term and authorize the dealer to carry out the sale. Director refused to comply with the wishes of the member, whereupon it was contradicted on behalf of the member that they were principal and director being agent were bound to give the effect to the member. So we have to explain as per this. And contravention of member against the non-compliance, which is director tenable or not. Okay. So let's go for 1 point because we know the answer, yes, but we have to go through also a little point which is related to 181 subsection 1 and clause A. ठीक है. So whether they can go for it, नहीं, they cannot go for it. ठीक है, they cannot go for sale, lease of undertaking, substantial and all. ठीक है. So here the director cannot go for that. Let's go for B wala part, 5th ka B. Runway Infrastructure Limited enter into a contract with the Royal Forging Partner Firm in which the wife of the Parthik, a director of the Runway Infrastructure Limited, is a partner. The contract is of supply of certain component by a firm for 3 years with effect of itna. Explain the requirement which should be complied with. Dekho, first of all, here that is going to be a related party, and with that related party there should be no transaction done. So this is going to be like the contravention here, okay. So this is not going to be, the contract is not going to be valid in this case because there is going to be a related party. Let's go for the other point. Is it mandatory to appoint the regulatory authority for a scheme of approval? Hanji, we know there are some of regulatory authorities. कौन से थे? सेबी थे क्या? RBI थे क्या? हाँ जी. लिक्विडेटर थे क्या? हाँ जी. सेंट्रल गवर्नमेंट थे क्या? हाँ जी. कॉम्पिटिटिव कमीशन एक्ट थे क्या? हाँ जी. So they are all the regulatory, and the regulatory can appoint the representative within 30 days of notice and documents sent to them. ठीक है. So yes, it is important. Let's go for 5C का second part. You are an individual shareholder found that the director representing majority of shareholder perform illegal or ultra-will. What is the action restrain this act? Now you have to read this point, guys. Okay, let's read quickly. This was related to basically वो वाला part, I guess, majority वाला shareholder ना. Let me read question. Okay, so in this case the notice to be sent to regulation नहीं, ये वाला तो हो गया है. Where is the question? Just a second now. Okay, the majority of shareholder have no right to confirm or illegal ultra-virus transaction in the company. In such a individual shareholder had to restrain the company by the order of injunction of court from the carrying out the ultra-virus act. This is what they are saying. Simple है, दो मार्क्स के आंसर है. ठीक है, लेट्स गो फॉर दी सी पार्ट विच इज SCRA से रिलेटेड एंड आई हैव ऑलरेडी mentioned in my notes what how the recognized stock exchange can delist, remember, and how from where they can go for appeal SAT within 15 days maximum extend हो सकता है. ठीक है, what is the suggestion framework for the business reporting business responsibility reporting, which is of 6B, and there are 3 part actually, part A, part B, part C. Part A is about the basic information and data about the operation of the business entity. Second, part B says about its the business performance. Part C says about the impact, the aspect of business responsibility reporting. Okay, first part C का first again है, part C का second है, which says about the disclosure on business on negative consequences, and the part C be aimed at encouraging the business continuing with improving the performance and the standards. Okay, so this is all about this part. Let's go for the 6 का C. The management of the Gangotri Limited was taken by the secured creditor. Remember what is going to be section 15 का question है. ठीक है, अपॉइंटमेंट कर सकते हैं, सेम वाला, अपन को पूरे प्रोविजंस पता है. तो yes, this is about the section 15 सरफासी एक्ट 2002. लेट्स गो फॉर 6 का डी पार्ट. गाइज देखो पता है क्या है ना, वी आर एबल टू सॉल्व दिस क्वेश्चन बिकॉज वी हैव डन अ थॉरली रिविजन प्रॉपरली. ठीक है, अगर आपका रिविजन प्रॉपरली है, आपको प्रोविजंस याद है, तो यू कैन फ्रेम दी आंसर ईजीली गाइज. सो ऐसा क्वेश्चन पढ़ते ही अपन को हो रहा है सारी चीज़ें, क्वेश्चन ठीक है सॉल्व हो रहा है, मतलब अपने को पॉइंट्स याद आ रहे हैं, तो यू आर डूइंग ग्रेट. Okay, so let's go for D point, which is during investigation conduct on affair of the company in public interest, the inspector observe the direction of the company that have been acting in instruction of holding company and proceeding investigation of the company. Is the inspector permitted to do under the provision? Do you remember? हाँ जी, 206, 7, 8 किससे रिलेटेड था क्या? हाँ जी, रिमेंबर. सो दिस इज रिलेटेड टू दैट पार्ट गाइस. ठीक है, तो इन्वेस्टिगेटर have fully right to go for that. So let's go for question number 7. What is mean by corporate governance? Yes, we know. State the major characters of the good corporate governance. So yes, these such kind of question you can easily frame the answers. ठीक है, you don't need to do ratification. ठीक है, आप अपना थोड़ा सा दिमाग यूज़ करेंगे, आराम से आप क्वेश्चन कर सकते हैं. Let's go for B वाला part, which is related to 7 का B वाला पार्ट, विच इज़ रिलेटेड टू पेनल्टीज. ठीक है, एंड आई एम जस्ट गोइंग टू बी वेरी क्विक गाइस. ओके, पेनल्टी अंडर सेक्शन 15D ऑफ SEBI, it's related to not less than 1 lakh, maybe extend up to 1 lakh, and up to maximum is going to be 1 crore, 1 lakh for the continuation. ठीक है, 15F failure to issue act, which is not less than 1 lakh. Penalty under 15HA, which is related to fraudulent and unfair activity, which we have already done the question, not less than 5 lakh, which may be extended up to 25 crore. Remember? Yes. And penalty for under 15HB for no separate penalty, remember 1 lakh and maybe going to be extend up to 1 crore. Yes, that's it about this point guys. And state, let's go for the section 7C. State some of the devices by which trade based money laundering is done. Remember I told you about the real estate, ये सब ठीक है. With that some fake invoices, over invoices, under invoices, duplicate वाला transaction को show करना, repetitive transaction show करना, these are the major way by devices where the money laundering can be done. Let's go for the question D, which says about the Mr. Daksh, an Indian national desire to obtain a foreign exchange. So whether he can do for that payment, number 4 says about the payment to made for a health securing health insurance for the company abroad. And second says about the payment commission of the export under the rupee trade वगैरह वाला point. Do you remember this point? Yes, schedule first, second, third वाला point we are going to read here. ठीक है. So drawal of the foreign exchange securing help from a company abroad does not fall under schedule first, second, third. Therefore, such a transaction permitted without any restriction or a condition. And second, for the state export under rupee state route, do you remember? There is commission up to 10% of invoice of export of tree and tobacco is allowed. ठीक है. So this point can be done. If it exceed, then again you need a approval. Their function of winding up of committee, ये वाला पोर्शन नहीं है. क्वेश्चन नंबर 8 का फर्स्ट अपने को नहीं है. What are the duties of interim resolution professional? We know this guy. It's damn easy. अपन कर चुके हैं. And sufficiency of asset with reference to 64F. Yes, ये अपने को पता है. Unpublished price sensitive information अपने को बहुत अच्छे से पता है. And OECD guidelines, yes, ये भी अपने को बहुत अच्छे से पता है. Which is related to stake role of honor or stake owned enterprise in the marketplace, equitable treatment to the stakeholders, shares holders, and disclosure and transparency जो अपन पहले ही कर चुके हैं. ठीक है. So yes, अपन we were easily able to guess the answer and guess the sections. So yes, अपन अच्छे से कर सकते हैं. मुझे लगता है तैयारी थोड़ी सही चल रही है, राइट? तो दैट्स इट गाइज. बहुत लंबा टाइम खींच लिया मैंने आप लोगों को. ठीक है. So we have done 5 previous year question paper, not in depth but thoroughly we have done, and we were able to solve or guess the answer properly majorly. ठीक है. So yes, hope so आपकी तैयारी भी बहुत सही चल रही है. नहीं चल रही है तो मैं क्या कहूँ, करनी तो चाहिए ना अच्छे से तैयारी. ओके. एंड विद दैट टुमारो वी आर गोइंग फॉर सम ऑफ द मॉडल टेस्ट पेपर. ओके. नॉट लाइक फॉर द 8 अटैम्प्ट तो नहीं कर पाएंगे, बट फॉर 3 अटैम्प्ट विल गो फॉर दैट. एंड विद दैट MCQ. ठीक है. एंड yes, we have this is our 6th day so far is my knowledge, and today will be our last day of revision. Okay. And I've completed the major part in 5 days. Okay. So yes guys, we'll meet in our tomorrow session. तब तक पढ़ते रहो, मस्त रहो, खुश रहो. Okay. To those guys.